Good afternoon, and welcome to the Appellate Division First Department. Most of you are familiar with how we operate. I will call the calendar, and I'm going to ask you to give me the time that you need rather than the time that you want. Understanding that I have 7 hours of requested argument time, which would keep us here till 9 p.m. And I can assure you that your colleagues at the end of the bench don't want to be here till 9 p.m. So please adjust your time wishes to what you actually need, not what you want. And understand that the time clock is for you, not for the court. So if your arguments are brilliant and it forces us to ask more questions, we go beyond the time, okay? So with that, I will begin the call of the calendar. People versus Kuchama. Submitted. Good start. 558 7th Avenue versus PKNY 4th. Okay. Do you want a rebuttal? 5. 5 and 5. R. Sherry versus Keith R. is submitted. Mosqueta versus TF Cornerstone. Okay. 5 and 1 and 4. Aponte versus Uber Technologies. Okay. Well, you're by yourself, so 3. You got it. Envision Healthcare versus XL Insurance. Okay. 4 and 2 and 5. People versus Clementon Allen. 4 and, okay, I'll do 4 and 1 since you asked for 5 on your request. Go ahead. Okay, 4 and 1 and 4. Oh, I'm sorry. I was reading. You're right. Still 4 and 1 and 4. People versus Anthony Carey. Submitted. Madison Hospitality versus Acasia Network.
4 and 1 for the Italian.
Okay. 4 and 1 and 4. Swallows versus West New York Times Square. Submitted. People versus Christopher Maldonado.
6 and 2.
Okay. 5 and 1 and 5. People versus Alcadir Jones.
Yes, for the appellant, I request
3 and 1.
3, Your Honor.
3. And I'm sorry if I mangled your client's name. Board of Managers versus Zimmerman Architects.
Appellant 7 and 2, please.
Okay.
For respondent 5.
7 and 2 and 5. Friedman versus Bloomberg.
Your Honor, for appellant 7 and 2, please.
Okay.
Respondent 5.
All right, let's do 6 and 2 and 5. Ciano versus Riverdale SNF.
I guess for the plaintiff appellant, 7 and 2, please.
Okay.
On 7.
Okay, let's do 6 and 3 and 7. Murray versus Stone.
Appellant's 4 and 2, please.
Okay.
And 6 for respondent.
4 and 2 and 5. People versus Edwin Lopez. Submitted. People versus Norman. Submitted. Rabinowitz versus Clark. Submitted.
Oh, okay.
Oh, sorry.
You can submit it if you want.
Well, you're here by yourself. Do you want 2 minutes to say something, or do you want to submit? All right, 2 minutes. I don't want to scare you away. Jones versus Workman's Circle is a submit. First case on the calendar to be argued is 558 7th Avenue. You may proceed.
Thank you. Good morning, judges. I'm Heidi Bermond, if it may please the court. I'm here for the appellant Grab and Go and Sid Sohail. This is a very interesting case because we have various decisions and orders from different judges. Basically, there was a management agreement, which has been held to be a management agreement between Grab and Go and PKNY, which was Papaya King, the hot dog company. My client, according to this management agreement, was to manage the premises, pay the rent, etc. When they got a notice of termination from the landlord, they brought a Yellowstone injunction.
So how do you, notwithstanding the various successive orders that address the judgment for use and occupancy, how do you get past the original order of Judge Schechter, which determined that the principal, Sohail, I'm sorry if I'm not pronouncing his name correctly, is on the hook? I know that all the key issues that you've raised affirmatively in this action, in the underlying action, how do you address that issue in terms of res judicata and/or collateral estoppel?
Well, that action was a Yellowstone proceeding, and if you read the decision, you see that the judge, probably rightfully so, was very angry. She felt that they had brought that action not being the actual president of PKNY, but as a so-called occupant or manager. Sohail never individually occupied these premises. He never claimed to. And interestingly, if you actually read even respondent's brief, you'll see, even though they keep—
We actually read
I know,
everything.
I know, I'm sorry.
Okay?
Forgive
So
me.
I,
Forgive me.
okay.
But what they say is that it's PKNY that surrendered possession to them in December of 21. It wasn't Grab and Go, it wasn't Sohail, because they weren't actually in possession. It was a management agreement. We couldn't surrender, we couldn't take over. But now what they're trying to do is hold Sohail individually responsible as well as Grab and Go. So what they're doing is they're saying if you have a management agreement and you're a manager, you are now responsible. The Yellowstone was premised on the fact that in that proceeding, Grab and Go agreed to pay a monthly use and occupancy pendente till there was a decision. They didn't pay it. The judge was not happy about that and ordered use and occupancy be paid in that proceeding. That proceeding was then over. This is a new action they commenced, seeking use and occupancy for a different time period.
But what I'm trying to raise earlier is the import or the controlling aspects of Judge Schechter's order, where she determined that you were occupying the premises and held that Mr. Sohail was personally liable, along with G&G, for the use and occupancy and set the amount for use and occupancy. You filed your notices of appeal of that order.
Correct.
And did not perfect it.
Correct.
And based on well-settled appellate case law, that is a controlling principle there, factual findings. So now you're coming here saying, hey, I'm not on the hook because I'm a member of the LLC. I'm not on the hook because I didn't occupy the premises, even though there's other parts of the record that show that you had a control as to what went in there, et cetera, et cetera. I'm trying to understand how you could just escape the controlling aspects of Judge Schechter's order.
Because it's for a different time period also, Your Honor. It's not for the same time period. During that time period—
But what agreement says that her order falls only under that time period?
Because I believe in order to find us liable for the other time period, you'd have to have a hearing.
Based on what?
What if they said we were liable till today?
No, based on what? Not
Based
what
on-
if.
Based upon
based on
not
what?
the same parties, not the same facts then. You're not the same parties, you're not looking at the same claims. PKNY, it was the tenant of record. And in that order, it says that there's a claim against PKNY as well. Well, they let PKNY out. They settled with PKNY separately. They made a whatever agreement they made, I don't know. And PKNY surrendered possession to them. So based upon that, I believe the facts are different and the parties are different. And my client had a right to at least have a hearing as to what the use and occupancy should have been if he was actually occupying during that period.
Who's occupying the premises now?
We don't have it. It was given back to—
What's that?
It was given back to the landlord by PKNY. So PKNY,
When was it given back?
I believe it was December 2021. It was given back by PKNY. They surrendered possession.
And the use and occupancy covers the period until when?
December 8th of 2021. But there's no indication that we were still in occupancy.
Well, isn't there an indication that Yankee Doodle Dandy Chicken Restaurant is in the premises?
I'm sorry, say that again.
Isn't Yankee Doodle Dandy Chicken Restaurant in the premises?
I don't know if they were in the premises or not.
You have a follow-up?
I mean, they were given back it was given back by PKNY, not by us.
All right, you'll have time on rebuttal.
Thank you.
Oh, actually,
have
you
a
didn't ask for rebuttal.
I didn't ask for rebuttal.
All right.
Sorry.
You may proceed, sir.
Certainly, thank you. Good afternoon, if it please the court. Paul Gruber, Borough Goldstein, Altshuler, Nains, and Goydell, PC. I'd like to remind the court that in addition to the Yellowstone action before Judge Schechter, there was
Just to
a
pick
third.
up on what your colleague finished with, Yankee Doodle Dandy Chicken Restaurant is now in the premises, right?
There was at a time, I don't believe they are right now, PKNY vacated, and their record indicates that once the Yankee Doodle principals learned that Mr. Sohail wasn't the landlord, they vacated the premises. That was probably before December 2021 when we got back the keys from the tenant of record on the lease. There was a third-party action commenced when we found out that Mr. Sohail misrepresented that he was the president of PKNY, Papaya King. And Judge Schechter, in extensive litigation before her, made the determination, based in part on admissions made by Sohail and Grab and Go, and if I'm mispronouncing Sohail, I'm sorry, that
But it turns out that the entity that's in the premises is Grab and Go.
they were in control of the premises. Grab and Go was operating there for a time, according to this record. They were in control of the premises and represented that they would pay use and occupancy. Now, the law is very clear that you don't have to be the tenant in order to be responsible for use and occupancy, but we don't even have to make that determination here because Judge Schechter made that determination. They appealed it. Sohail and Grab and Go appealed it. Those appeals were never perfected. This court refused to vacate the dismissal of those appeals that arose under the operation of the court rules.
What about the amount of the use and occupancy? She gave a judgment based on a certain amount. Should there have been some type of hearing to determine what the use and occupancy would be for the time after that?
No, Your Honor, because the use and occupancy that we sought and were awarded was no different than what the rent was specified in the lease.
So it did not change during that period of time?
No, it didn't. No, it didn't. You know, the lease might have, said for 2020, it's higher than 2019, et cetera, but it was the lease amount that we asked for, and that was the lease amount that we were awarded plus whatever statutory interest. Nothing more, nothing less. So under the rules of Bray versus Cox, and res judicata, we can't relitigate what Judge Schechter decided, unless the court has any further questions.
Thank you.
Thank you.
Mosqueta versus TF Cornerstone. You may proceed.
Thank you, Your Honor. May it please the court, Thomas F. Marr from Perry, Van Etten, Rosansky, and Kuttner on behalf of the defendants' appellants. The basis for our appeal here today is that we strongly believe that the lower court improperly granted plaintiffs.
Counsel, there was a case coming out of this department in 2022 which seems to be on point, the Vitucci case, factually with this particular set of facts. And I noticed in your brief you didn't address this case, and there was no reply brief that was. Do you want to address that now?
I would love to address that. Thank you, Ron, for bringing that up. So counsel for plaintiff goes out of his way to say that this case is controlling. And if you look at the facts of that case, they are dissimilar, specifically in that in the Vitucci case, it was undisputed that the area to set up the ladder was inadequate. In this case, that's the center of the defense.
And in this case, how was that established by your side?
I didn't.
The area where the ladder could have been set up, was there any measurements or anything that was
Well,
set
the
forth?
expert that we retained and submitted an affidavit in opposition to plaintiff's motion for summary judgment had an opportunity to measure the ladder that was
He
involved.
didn't get to see the ladder that was actually used, did he?
So the contractor that TF Cornerstone used in this incident was someone that they used all the time, and they permitted that contractor to keep their materials on site at the time of the accident and continuing through to the time when Mr. Yarmus did his examination. So Mr. Yarmus examined the ladder that was involved in the incident, and
Did he
No, he
say
didn't.
that inside his report? I thought that he said that he examined a ladder that was maybe 2
the
feet.
ladders. I'm sorry.
There was a difference of 2 feet. The ladder that he examined was 4 feet in height, and the ladder that the plaintiff alleged that he used was about 6 feet in height. And the expert said that it wasn't the same ladder.
What the expert did was measured the ladders that were maintained on site. The plaintiff said a lot of things. Plaintiff said that he couldn't have set the ladder up. There's nothing to support that other than his own
The
self-serving
problem
testimony.
is that you make the motion, right?
I didn't make the motion for summary judgment. Plaintiff made an
Plaintiff makes
affirmative
the
motion for
motion.
summary judgment against me. I don't have to prove that, I'm
Yes, but your
dismissing
expert
240.
has to establish that the actual ladder could have been opened in the spot that the plaintiff said he
And-
couldn't, and he didn't.
I believe that he did do that by the measurements that he made. And counsel in this case, is citing to a case where it's completely different. In the Vitucci case,
I was on Vitucci,
okay, well.
and
if
this
I-
is on all fours with Vitucci. So I don't see how you get past Vitucci. And your expert affidavit, without any measurements whatsoever, it's this.
No,
Doesn't
he
give
does
us
contain measurements.
any measurements
That's
whatsoever.
That's not true. He said that the ladder was less than 19 inches in width, and that it
Except
stood
he doesn't
44 and
inspect the
3/4
actual,
inches.
counsel, he doesn't inspect the actual ladder.
He
So
inspected the
everything
ladders
he
that were
said-
used by the company. And again, I just want to finish this point.
I just have to tell you that it's not good for you when you cut off the court.
I apologize, Your Honor, if you feel that way.
Because you don't know what I'm trying to ask, and you're cutting us off before we get our question out. But you go ahead and make your argument.
I'm sorry, Your Honor, but what I'm trying to point out is that the expert in the Vitucci case was a biomechanical engineer whose argument was limited to the idea that the person could have done the work standing on the floor. In this case, that's not the argument that we're relying on here. We're relying on the fact that the ladder could fit, that the plaintiff admits that it was available for his use, and he also admits that he decided not to use it. Therefore, under the
He
case...
said he couldn't use it because he couldn't open it.
But
That's different from the ladder fit, and I chose not to use it. Am I right?
The plaintiff made no effort to use the ladder. He decided he wasn't going to use it. The plaintiff's contention that he couldn't fit the ladder is based upon nothing more than his own. Plaintiff has no measurements as to anything. Plaintiff has...
He's the actual worker who tried to open the ladder in the space, and
He didn't
couldn't.
actually say that he tried to open the ladder. He just said that it was his custom to stand on the top of a bathtub, and he just decided not to do that. So he never had any intention of using the ladder, even though it was brought up to the spot and was available for his use.
Thank you.
May it please the court, John Shore for plaintiff respondent. What is most telling, as Justice Pitt noted, that conspicuous by its absence in defendant's brief is any mention of Vitucci, which was, as Justice Manzanet indicated, square on all 4 points here, and it was relied on by Justice Suarez in the lower court. Clearly, Vitucci is on point here, and unlike Vitucci, there's even further grounds for summary judgment because in Vitucci, they could have made an argument, which they did, well, the boxes were obstructions. I mean, they could have argued, they could have even moved the boxes. Here, the record is uncontroverted that my client could not open up the ladder to do the work.
I mean, even though the defendant's expert did give some measurements based on a ladder, which may or may not have been the one that was used or was allegedly similar to it, they didn't take all the different measurements, did they, to get the length to really flesh out whether or not they could have opened this ladder in this bathtub?
That is correct, Justice Kapnick. That's why, similar in Vitucci, this court completely disregarded the complete speculation on the part of the expert, and as well as experts in multiple cases where there's a summary judgment motion in Harama, where it's basically, with all due respect, junk science here.
Does the workman's compensation report and the medical reports create an issue of fact as to how the fall may have occurred, whether it was the plaintiff standing on top of the bathtub and falling in because he wasn't furnished with an appropriate ladder, or was he just standing in the bathtub or fell? What do you say about the workman's compensation and medical reports?
Absolutely, Justice Friedman. On 2 counts, it fails. First of all, under the law, there was no proper translation for the workers' comp form. There was testimony, well, someone acted as a translator on behalf of the plaintiff. That's not legally sufficient evidence, and it's been routinely rejected by this court in the Nassau case, Eustaquio, Nava, Juarez, the Sanchez
Has
case.
it been rejected as to medical reports also?
Because it was also hearsay and not a proper translation. But even if it was proper, let's assume for argument's sake, there's nothing inconsistent. My client consistently testified at his deposition that he fell in a seated position, which is completely...
Putting aside whether there's an inconsistency or not, but if there's a medical report, just let's speak generally, if there's a medical report which has a version of events, and let's say it's not hearsay because it's necessary for treatment, does there need to be an indication of who interpreted for the doctor or for the medical providers before that medical report could be used?
Absolutely. First of all, it was the only evidence. It was complete hearsay, and it again, there's cases directly on point that it was not properly translated, and they had every opportunity to get a translator, but there's no inconsistency anyway because they're trying to misapply the evidence here. My client testified he was standing on the edge of this bathtub, and he fell in a seated position.
He didn't testify just that. He was testifying, or at least in his affidavit, as I understand it, it was the custom and practice for the nature of the work he was doing to stand on the tub top because he had to do precise work with a brush, and which totally goes against what their expert was saying, that they could use a roller with a stick because this particular work required precision. That's what your client said, right?
Absolutely, and then there's nothing to controvert that
Correct.
He couldn't fit it into the corner. They didn't get an affidavit from the foreman. They didn't get an affidavit from any coworker to controvert that he could not do the work as he testified. In fact, in the Vitucci case, they got an affidavit from the foreman who tried to contradict what the plaintiff said, where the foreman said, actually, Vitucci could have done the work in a standing position. And this court disregarded that correctly because at most it would go to comparative negligence. There was no specific warning. There was no directive. But unlike Vitucci, in this case, it was the custom and practice. He was there for 2 years. That's how they would do the work. And there was no directive, no evidence of him being a recalcitrant worker. Nothing in the record other than this speculative affidavit from someone who supposedly did an on-site inspection 4 years post-accident of some ladder that wasn't the ladder at issue here.
Thank you.
Thank you, Your Honor.
You have 1 minute.
Yes. Just on the issue of the medical records, counsel has taken the position that medical records are inadmissible, but our position is that hearsay documents in the context of a motion for summary judgment can be considered by the court so long as it's not the only evidence. In this case, we have both expert affidavit and medical
Except that on a
records.
medical record, any hearsay has to, one, be attributable to the affiant, right? So it has to say the patient said, and where you have a language translation, there must be a certification for that translation. So I agree with you that hearsay is okay on a summary judgment motion so long as it's not the only, so long as the hearsay evidence that is being considered is properly received. And here, because there is no certification on the translation, it is not. That's the issue.
Well, I think the court should consider that in conjunction with the affidavit of the expert.
No. It's a question with respect to the statements of the plaintiff. Whether we can consider them, they have to be certified statements since they were brought to us through a translator for whom we have no certification.
I mean, these are statements from their own treating doctors.
It doesn't matter unless the doctor can certify that he or she understands Spanish, then I still don't know that the translation is proper. That's our case law.
Again, I think under the Garcia case, the court is permitted to consider documents such as the ones that were submitted in opposition to this motion, and in combination with the affidavit of our expert engineer, the lower court's order should properly be reversed.
Thank you. Aponte versus Uber Technologies.
May it please the court, Jeremy Hellman for plaintiff appellant. In this motor vehicle case, we concede that the limousine that overtook the Uber vehicle that my client was a passenger in was at fault. There was fault on
So
behalf
why
of
are
the
we
Uber.
here?
We are here because the Uber vehicle also has liability, or at least has not.
How?
They have
We
not-
all saw. I mean, seriously, this is as close to frivolous as it gets. As close to frivolous as it gets.
The reason for our contention on this matter is that defendant has not sustained their burden of proof, which was, as movement, to show that they took reasonable care to avoid a collision. Here, they've done nothing to say what they did, what the driver did. Instead, they only point to the other vehicle and say what happened with the other vehicle.
And there's a video, right?
There's a video.
That we have all seen,
Yes.
that shows the limousine cut off the driver of the
Yes,
Uber.
and we have no indication from the driver of the Uber vehicle, whether he saw, whether he was looking, whether he could have stopped, whether he tried to stop. We have nothing.
We should ignore what we saw with our own eyes?
Well,
I
don't know what.
come on.
We don't know what the Uber vehicle had.
Tell me, what could he have done?
He could-
Based on the video you and I saw, what could the Uber driver have done?
He was going so slowly. He could have easily.
What could he have done?
He could have stopped. He could have.
And how would that have prevented the limo from hitting him?
The limo did not hit him. He hit the limo in front of him.
Okay.
That's our contention. It's very clear in the video that the Uber vehicle strikes the back
Counsel,
of the sketch limo.
Please don't tell me, explain to me what I saw in the video. It speaks for itself. And I can't speak for my colleagues, saw nothing that the Uber driver did wrong. So tell me, what did I miss on that video?
He hit the rear of a stretched limo that came all the way in front of him.
That cut him off.
And he had plenty of time because he was going so slowly that he could have avoided colliding with that car.
Okay.
And certainly he hasn't sustained his own burden of telling us. It could be on the record that we have in front of us, it could be that the Uber vehicle intentionally hit the car in front of him. We don't know. We don't know. We should know. At the very least, we should know that based on the affidavit. But the affidavit of the driver is silent. All he does is say, oh, this other car did this and this and that, but he doesn't say, oh, I was looking, I couldn't stop. Nothing. So under these circumstances, we feel that he has not sustained his burden. We should take his deposition. We'll find out. We haven't gotten his deposition.
Thank you.
Thank you, Your Honor.
Envision versus Healthcare. You may proceed.
Good afternoon. If it please the court, Elizabeth Morris with Latham & Watkins on behalf of Plaintiff Appellant Envision Healthcare. I'd like to introduce my colleague Michael Byrne, who is admitted pro hoc vice, who will be presenting the argument.
That application is granted even though we have over 100,000 perfectly qualified lawyers in New York, but welcome to our jurisdiction. You may proceed.
Thank you, Your Honor. Good afternoon, and may it please the court. The key reason why our allegations state a claim in this case, while those in CRO did not, is because we specifically made the allegations that the Court of Appeals held to be necessary in CRO but lacking in that case. And to be clear, this wasn't some effort to plead allegations after CRO came out to fit into that decision. We made our allegations a year before the CRO case came out. Let me start with what I think is the most straightforward point. We allege that the SARS-CoV-2 virus attached to various medical equipment and supplies which could not be cleaned and had to be disposed of.
So you're saying that in the course of your ambulatory surgery centers, outside your facilities, there were huge dumpsters where you were throwing out hundreds of thousands, if not maybe millions of dollars of equipment because you claim the virus was absorbed into the coverings of this equipment. Is that what you claim?
I can't speak to the specific numbers.
Which would mean that this kind of theory would be shared by almost every hospital, medical center, all over the country. Well, and that means everybody was throwing out millions and millions of dollars of equipment because of the theory that you've advanced here.
Well, I guess I would say two things about that. I mean, one of the things that's very interesting is there certainly have been other claims that have been made by medical facilities or hospitals, but most of them haven't actually made this allegation. Most of them have been loss of use type of allegations, or the idea that there were less patients and there were business interruption.
And it's fair to say that your medical centers, your surgery centers did not shut down completely.
Some of them did, actually.
Okay.
But I think with respect to this, the opposing counsel hasn't pointed to a single court case in which any court faced with this type of an allegation that the virus is, and this is an allegation that's supported by an expert report that we attached to our complaint, which notes that that explains that we had the virus was attached to medical devices. Go ahead.
If indeed the coronavirus could penetrate plastic surfaces, vinyl surfaces, whatever these machines are made out of, then why wouldn't every single hospital all across the nation have had to do the same thing? I'm trying to understand how this is a legitimate claim in light of the fact that every single hospital in every single state in our nation dealt with this.
So completely understand your question. I guess I would say two things about that. First of all, with respect to whether we could prove, that the coronavirus required us to throw out equipment, that is absolutely something that the other side can contest. But it's just something that has to be contested in discovery. But I do think that I'd want to make a distinction. We're not saying that every surface within the hospital had to be thrown out, right? We're talking about specifically medical equipment and supplies, and of course in a hospital.
No, and I'm talking about equipment because we know that hospitals across our nation weren't torn down to the ground and rebuilt because surfaces were exposed to coronavirus. And hospitals continue to be exposed to coronavirus to this day.
Right.
So I'm trying to understand, because I'm an avid news watcher. I didn't see news throughout the nation that hospitals throughout our nation were throwing out equipment because their equipment was now infected.
I can't speak to why other facilities haven't. had
Counsel,
major-
but you understand how if only your hospital, only your client's equipment suffered this, every other hospital in the whole nation was able to clean and reutilize the equipment after whatever process they engaged in. I'm trying. You understand why I am just
I
like
completely
this
understand it.
seems a little.
But I think that the relevant point here is that we are at the pleading stage. I think they're absolutely entitled to say, why is it that you had to do this? If
Counsel,
supposedly
and
others
normally, I could agree with you on there's different standards when we're talking about 3211 motions before and talk about 3212 motions. But in this particular instance, where it seems that the law is very settled and that the view of what constitutes an actual and complete and persistent dispossession is settled by the Court of Appeals, and dealing with COVID-19, those things are settled. What are we really doing here?
I think you're absolutely right that the CRO decision settled the law, but we think it settled it, at least with respect to this allegation, in our favor. You'll note that the other side didn't even respond to this allegation in their brief, and they pointed to no case in which allegations like this have been considered and rejected by any court, New York or otherwise. So we think that this allegation gets through. I'd like to just briefly address two of the other things that we talk about. One is the HVAC system and the allegation that we've had to make repairs here. Again, they're entitled to make arguments about why they don't think we needed to repair our systems, but I think it might be helpful for the court to understand the nature of the argument here. If we were, imagine like at home, if you had some foreign substance that got into your washing machine and it got lodged deep within the agitator, and as a result, anytime that you washed your clothes, the clothes emerged stained from your washing machine. I think we would all, in that circumstance, view the washing machine as having been damaged.
Okay, taking that one step further in this context with COVID-19, every single time there's an alert on the news that COVID is on the rise and people are now going back into hospitals or seeking treatment, HVAC systems are now being required to be replaced.
I don't think that they are always required to be replaced, and I think there are differences in different time, right? Like the way that we react to COVID now is very different than how we reacted in 2020. There were differences in terms of the lethality of the virus and what our reactions were. But I think, again, these are arguments that the other side can make in discovery, but we do think we pled enough. And the last thing is, with respect to the facilities, unlike in the CRO case, in the run-of-the-mill cases, what most parties have argued in these insurance cases is they say, as a result of COVID, there was less foot traffic. We weren't going to do as well economically, or we were scared about COVID, and we closed our facility. That's not what we alleged here. We alleged here that that because there was so much COVID in our medical facilities, and the other side doesn't dispute, obviously, that medical facilities were uniquely exposed to the COVID virus. We argued that rendered the facilities uninhabitable. Now, we've made that allegation. We do think CRO suggests that allegation is a permissible allegation. There's basically two arguments that the other side has made in response to that. One is the argument that how could it be uninhabitable if there's still people there, right? If there's still people performing work in the facilities. And our answer to that is that uninhabitability doesn't require abandonment. I think all of us accept that you could show physical loss if, for instance, there had been mold or radiation or ammonia that made it so that it was too dangerous to operate. May I finish?
Yes.
Thank you. Too dangerous to continue to work in the facilities without some sort of protective gear. Now, the fact that in this case doctors adorn themselves with protective gear, surgical gowns, and we even talk about in the complaint gas masks in certain situations because PPE wasn't available. It's no different than a scenario in which, if radiation had come to the hospital or mold had come into the hospital, but people continued working while using protective gear, we would still be able to make an argument that that's rendering the facilities uninhabitable. So again, we think at the pleading stage, we've done enough here. We know that
The problem with that theory is that while your doctors are masked up, not all of your patients are. Okay, and not your janitors and not secretaries, etc. So that argument falls flat because not everybody in that hospital is masked up like the doctor.
may I just quickly respond to that? My understanding is actually the requirement in the facilities was that everybody needed to be masked up. That's my understanding.
A little mask versus the kind of masks that we saw on doctors during the height of COVID. You're not gonna you're not gonna stand there and tell me that everyone in every hospital was wearing all of that equipment to answer phones. That's not true. It's just not true, and you know it. But you'll have time on rebuttal.
Thank you, Your Honor.
Hi, Your Honor. My name is Gabrielle Siskin.
Another application. And we're gonna welcome you too. Go ahead.
Here to introduce my colleague Dan Malay on behalf of defendant respondents Excel Insurance America Inc., who has been admitted pro hoc by this court.
And that application is granted. And again, I welcome you with the same proviso. Go ahead.
Thank you, Your Honor. May it please the court, Dan Malay from Zell LLP for Respondent Excel America. Cutting right to the chase, we cited in our brief 3 other hospital medical center cases in New York where similar allegations were made, and I'll get to the distinction that counsel draws. That was Wellpath, state court case, Northwell from the Southern District, and Hudson Valley Bone and Joint, also from the Southern District. None of those plaintiffs used the technical scientific argument that why are these droplets attaching to surfaces? But they all made the argument that these droplets attach to surfaces, and that's physical loss or damage. The fact that a scientist has provided a declaration that explains the chemical nature of that connection, that adsorption that causes the particles to adhere to solid surfaces, doesn't change the fact that the solid surfaces aren't damaged. That chair may have COVID particles.
Does that mean there's a physical alteration?
There is no physical alteration. The substance, the virus, is attaching to the surface, but the surface doesn't change. And as I was about to say, Your Honor, that chair that counsel's sitting on may have COVID particles on it right now. The chair on the other side of the table may not. They aren't any different. They're still serving their function. The one that is infected could be cleaned, but they can both continue to be used. And that's the same with the medical equipment.
They needed to be regarded as a physical alteration, don't they, to fall under the policy?
Yes, they do. And I'll get to that, Your Honor. The CRO case that is really the real basis for the legal argument that Envision is bringing had a very clear holding. And it established that under New York law, quote, we hold that direct physical loss or damage requires a material alteration or a complete and persistent dispossession of insured property. There's no material alteration here. On the dispossession point, the court went on to say, okay, if you're looking at direct physical loss, so the property's not damaged, but it's physically lost, what do you have to show? And the court said, this phrase encompasses impaired functionality and either a partial or complete loss of use for a limited period of time. That reading is untenable, though, because it would collapse coverage for a direct physical loss into coverage for loss of use. So what do you have to show, according to CRO? Maybe under New York law, it would be sufficient to show such a complete contamination by some substance as to render the property, to eliminate the function of the building, to render it completely unusable. And those are the cases that Your Honors are aware of involving noxious fumes, gasoline, et cetera, where some courts in some states have said that's enough. That is a loss of functionality. That is a direct physical loss of the building. Even though the building is still there, it's completely lost to the owner or the user. We don't have that here. These hospitals continue to be used.
What period of time would that have to be?
Well, the phrase that the court has used is persistent and complete. I would suggest that means this building is permanently lost to the owner or the user. But I don't think the courts have defined, outside of New York, have defined if there is a particular time period that has to be demonstrated. But it has to be persistent and complete, as distinguished from the factual scenario here, where Envision at times apparently closed portions of buildings because the surgical procedures they would otherwise have been doing were not allowed under local laws or state orders from the governors. So they didn't use that space for a period of time until they could use it again. There was nothing wrong with the space. It wasn't uninhabitable. They weren't dispossessed of the space. They just elected not to use it for their own reasonable business reasons, given the circumstances that they were dealing with. The last point I wanted to get to, Your Honors, is that there is a contamination exclusion in this policy. Many of the cases that you've seen only are about direct physical loss or damage because there's no exclusion that could arguably apply. Here, the contamination exclusion directly applies to this claim. The phrase in that exclusion is, the policy excludes all loss or damage, directly or indirectly caused by or resulting from loss or damage from contamination, which is defined to include virus, and any cost due to contamination, including the ability to use or occupy property, or any cost to make property safe or suitable for use or occupancy. That's exactly what their claim is. And certainly I think everyone is sympathetic to Envision's situation, and all of the medical centers.
It's their claim that they allege that the virus persistently contaminated Envision's facilities to the point that they were rendered uninhabitable, forcing it to close facilities altogether or sharply limit their use to vital purposes only. What about those allegations make them insufficient?
Well, they're factually not credible. What they're saying is there was infiltration of the virus, and then even if they cleaned, it would be infiltrating again because there's more people coming into the hospital space day after day after day.
So is it your position that this is just factually, clearly, and obviously inaccurate, or to the extent it may be accurate, it was accurate only for a very limited period of time, so it doesn't satisfy the policy? Where is the deficiency? Is it the lack of permanency? Is it the fact that it's just factually not true?
Yeah, the problem is it isn't persistent because they clean it, and does it happen again? Yes, but it isn't persistent, as is the case with the church saturated with gasoline.
Because they could always go back in?
Yes, they could always go back in, and they did go back in. And they didn't vacate these premises.
Could you address briefly the public policy issue that was raised by the plaintiffs? Because these were medical facilities that maybe there should be a little bit of a different standard than CRO otherwise found.
Yeah, as I said a moment ago, I think everyone is sympathetic to their situation, but businesses across the country, across the world, suffered from these same sort of problems. The fact that they're providing medical services, I don't think could create coverage under a property insurance policy. And I would also add, Your Honor, there is coverage for these sorts of claims, and some hospitals bought that coverage. It's always sublimited. The insurers don't give you the full policy limit, but it may be sublimited at $2 million or $5 million or $10 million. There's pandemic coverage that a hospital could buy, literally pandemic coverage. It is rarely purchased, A, because it's sublimited, and B, because it adds to the premium.
And it's very expensive.
It's very expensive.
Sure.
Right. I guess it'll be purchased a little bit more now.
Yes, it will, I'm sure. Thank you, Your Honors.
Thank you. You have 2 minutes.
Thank you, Your Honor. I'll try and just make a couple of points. First of all, with respect to this question of timing, most of the comments that counsel made were in regards to our argument about physical loss that goes to the facilities, not to the question of whether we've alleged physical damage with respect to disposing things or to the repairs to the HVAC system. So I just want to point that out. But with respect to the physical loss allegations, I'll note that the CRO court did cite favorably to a case that they rely on in their own brief, the Kim Chi case, where the length of time that was found to constitute physical loss was just 1 week. It was a situation where ammonia leaked. They evacuated a facility for 1 week, cleaned it up, and then people returned to it, and that was found to constitute physical loss. A couple of other things that counsel pointed to several New York cases. I just wanted to quickly address those. Most of those cases actually all of those cases predate CRO, and the allegations actually were quite different. So, so WellPath is a good example. In that case, the court found that in order to allege physical loss, you had to allege physical damage, We know that after CRO, that's not the case. Similarly, Hudson Valley was very much about pleading loss of use, not pleading physical damage. And in Northwell Health, it was decided on the premise that there was no allegation that the virus had prevented ordinary use and could just be made safe by routine cleaning, whereas obviously in our complaint, we did allege that routine cleaning was not sufficient to protect many of the equipment and our facilities in certain cases. Lastly, I'll just address the public policy consideration. It's not so much that we're asking for some sort of carve-out rule where medical facilities are treated different just because they're medical facilities, but they are factually situated in a different manner, right? So counsel talked about the 2 chairs, right? And one might have COVID on it and one might not. Well, that may not matter so much when I'm sitting on a chair, but it does matter a lot if I'm talking about medical devices that I'm about to insert into my skin, and one of them needs to be sterile, or else I'm putting a patient at risk. And so,
your allegation is that although the hospital would engage in the normal course of sterilizing items that you use to check patients, that notwithstanding that protocol, the virus would still be present, notwithstanding the cleaning protocol.
That is the allegation, and we, again, that's something that they contest.
Can you tell me where in your brief there's evidence that ever occurred? That there was cleaning of a surface and a check of that surface revealed that some coronavirus was detected after a cleaning process was done?
I guess I'd point to 2 things. One, I think, is paragraph 22 of the complaint, where we say that that medical equipment was that could not be cleaned, essentially, and had to be disposed of. So the allegation is that cleaning was insufficient, and same thing with the HVAC. There are definitely allegations.
But wait, it's not. Wait, you said 2 things. You said items that could not be cleaned. So if they could, are you saying because of the type of equipment it is impossible to clean it? Or that the attempts to clean it were not successful?
Yeah, I mean, I think it's possible that both could fit into that, and I think, again,
but don't you have to tell me which one it is?
Well, what I'm saying is it may well be that both of those things are envisioned by that allegation. I think that the idea is, and if you go to the HVAC, I'll give you an example of one that's specific to that. The HVAC.
What disturbs me about your response is that it seems like you're just throwing tissue at the wall and seeing what sticks. So my question to you is there evidence in the record, and tell me where I can find it, because I missed it, that tells me that there was an attempt to clean this equipment, whatever equipment, and that protocol for cleaning was unsuccessful because it could not do so of the coronavirus? Is there anything in there in the record?
Those are the allegations. Those are exactly the allegations we made about HVAC, that we tried to clean it, but the cleaning was not able to.
And my question to you is, what proof, other than saying that, what proof in the record is there of that?
But that's I think what discovery is for. We've made that pleading. We have said that we have made that allegation. They have the right to say that's baloney. You're not going to be able to prove that. But that's exactly why you have discovery. If they can show that no, this could have been cleaned, then they're going to prevail. When we get to summary judgment or trial. But I think at this stage the question is, have we alleged facts that allow us to proceed?
I think the point is before you start an action and file a complaint, you kind of like to have a body of evidence to somehow prove it along. I understand it's at the pleading stage, but this is a pretty serious allegation because almost every health facility throughout the United States has some type of HVAC system. Air conditioning, heat, I mean, it's integral to these structures, and they were all functioning. And air was going in and out, and protocols were in place. And this is a very serious allegation to say we can't clean these systems, and therefore we have to shut down in perpetuity, permanently, because this is impossible because the virus is going to sit there. And I'm struggling to understand this allegation as Justice Madison was raising with you. We're talking about every health facility throughout the United States would have had to shut down because this is pretty serious. You're asking doctors, every healthcare provider, with or without a mask, is at risk for breathing in the virus that you say is contaminating these air systems, and the patients are exposed to that, everybody walking into these facilities. That's a serious allegation.
Yeah, I would just say, you know, if you look at the, I mean, we point in our reply brief to specific paragraphs from our complaint.
No, you could plead it, sir, but my point is to now seek a claim here, as CRO made clear, it has to be permanent. The building is just gone. We're going to have to tear it down because it's contaminated, because we can't possibly clean it ever.
So let me be clear about that. That is not what we're saying. That is an allegation about physical loss. That's different than the allegation about there has been damage to either medical equipment or the HVAC. The HVAC argument is principally it's a physical damage argument, and as to that,
but if you're saying that the HVAC system of a hospital is physically damaged, then does that mean that the entire HVAC system, all the piping, all the tubing in the entire building has to be taken out and replaced?
No, it's no different. If your car is damaged, sometimes your car is
Forget about the car. I want you to answer my question about the HVAC
but
system.
I'm saying we put our money where our mouth is. If you look in the complaint, we spent a lot of money to basically take out things from the HVAC system and replace them. Not just filters, but also other aspects of the HVAC system that have to do with how you rebalance the air in a system in order to make sure that.
And then, so I guess then, okay, great, you had to do that. Did you do that every single time there was a coronavirus outbreak? Like, are you going to do that every single time?
No, because you don't. When you're changing the system, part of it is you're fixing the system in a way that you're trying to minimize the effect of coronavirus in the future. Now, obviously, you can't. There's not a perfect system. We can't protect.
And these are not the only. These are not the only air. Look, plenty of people catch staph infections at hospitals every day of the week in hospitals all across our nation and die from them. Hospitals don't sue and say, oh, there's a staph infection. So you understand what I'm saying? So I'm trying to understand how this is different from any other communicable disease that hospitals deal with every day in their facilities. Why is this different?
And what I can tell you is, in relation to all those other things that you just described, right? Like, we have all been around the common cold our entire lives, right?
Right.
The common cold didn't result in the massive kinds of costs that were incurred by our medical facility and perhaps by others in terms of responding to that. And the reason why is because this truly was unprecedented in terms of the order of magnitude, in terms of what the concern was. I mean, we know that, like, if you go on an airplane, you might catch the common cold, but we accept that. We never wore masks in relation to that. But when COVID was at its peak, we were all wearing masks. You were probably wearing masks here. It was different in kind. And I think, like, at the end of the day, to allege physical damage, right? We don't even need to prove that that the damage was life-threatening, right? Like, you can have physical damage with respect to using a car. You can have a scratch on your car. That's still physical damage. It's just the case that in a lot of other situations it wouldn't have caused that kind of breaking of the system. But this virus, because of how lethal it was, I mean, there's just a difference between a cold and a plague, and that's
Although
why we
now
had to
we're
do what we did.
treating this like the flu, but your point is well taken.
All right. Thank you very much, Your Honors.
Very interesting arguments. Thank you so much. People versus Allen. You may proceed.
Thank you. Good afternoon, Your Honors. My name is Mark Zeno, and I represent Appellant Clementon Allen. May it please the court. The court below erred when it found that the store manager had an independent source, allowing her to make an in-court identification. Respondent here defends the court's independent source ruling based on the court's conclusion that the store manager saw the suspect for 3 to 4 seconds and noted the suspect's unique features. Both of those findings by the court are factually
It was
wrong.
2 to 3 seconds.
It was
Isn't
2
that
to
what she testified to?
Correct, 2 to 3 seconds, and the witness noted nothing unique about.
Except that he was probably the only potential customer who walked into her store with a bag of fresh popcorn that filled the store with the smell of popcorn. And that kind of stood out to her, right?
The bag and the smell of popcorn absolutely did stand out to her, but did his face stand out to her is the question. She had no reason to think about him, focus on his face.
But she did say she did look at him for 2 to 3 seconds. There was no one blocking her, and she had a clear view. She did say that, didn't she?
She absolutely said that. And how much of that 2 to 3 seconds she spent looking at the bag of popcorn, determining that it was from.
It's all one mental picture. I mean, she looks over, she sees the popcorn, she sees
Smells
his face.
the popcorn.
I don't
She
think
smells
that
the
you-
popcorn and
I
she
don't-
sees his.
Sorry. I don't think that you can take a mental picture of someone's face when you're a greeter in the store, looking at their whole body for 2 to 3 seconds, noting the color of the sweater, the fact that he had popcorn, the fact that it was in a bag from Zaro's, thinking about the smell of it filling the store.
You're breaking up this picture. It's all one picture.
It's all one picture, but the question is whether she had enough basis to identify my client in court months or years later based on that glimpse. It was a glimpse. She was a store greeter. That's what she did all day. She said hello to the customers as they walked in the
So
store.
then your argument then goes based upon determination of credibility. If the court in that regards found her credible. First of all, I was surprised that the people conceded to an independent source hearing, and then that's how it went down. But that's what happened, right? And so now the person testifies as to what their independent source was. They testify about the popcorn that triggered, this, I guess, memory retention, and that was her basis for and that's what the court credited. What was there to show that that was not credible?
The fact that it was 2 to 3 seconds, and we know, unlike store clerks, we know, as judges and people who practice criminal law, we know that layman's perceptions about the ability to identify someone are overstated. The fact that you see someone for 2 to 3 seconds, and the people say no case where 2 to 3 seconds has been found to be adequate for an independent source, is just not sufficient to make an independent source determination. That's a legal determination.
But it's not really contingent on the amount of time, more seems to me the circumstances surrounding it, right? And really the only thing that would have separated your client from anyone else walking into that store was the popcorn, okay? People don't generally go inside Tiffany's with a bag of popcorn. So that would stand out. That would be something that, although fleeting, would stand out in somebody's memory. And again, why should, as my colleague said, why should we overturn the findings of the court in terms of credibility of this witness?
May I?
Yes.
It's not a question of credibility. It's a legal question of whether there's an independent source. Yes, she believed, I'm completely confident that the witness believed.
Right.
It's not a credibility question. It's a question of whether it was, the law allowed her to make an identification in court.
But in essence, you're asking us to reach a holding that, as a matter of law, a 2 to 3 second observation is insufficient for a identification, because that would be the only reason to say, no, we're not going to consider this then.
This 2 to 3 second identification is
Okay.
not any 2 to 3 second identification.
All right.
May I proceed?
Yes.
Good afternoon, Your Honors. Jacob Marcus for the people. The court correctly found.
Well, counsel, I mean, to be fair, independent source hearings aren't usually granted in this particular kind of scenario because what would be the independent source? There's no familial connection. There's no outside knowledge of this person other than this 3-minute random person. 3 second. Thank you. I was being too generous. 3-second interaction. So again, a little shocked to see an independent source hearing, but here we are. But why isn't counsel correct that as a matter of law, this is just not what this particular body of law is for?
I don't think that as a matter of law, this is insufficient because counsel zeroes in on just the one factor of how long was the opportunity to see them. But the Braithwaite Biggers factors, it's not just time. There's also the degree of attention and reasons that they had to pay attention to someone. Ms. Ledoux testified that she looked at him directly in the face, said hello to him, that it was her job to greet potential customers. I also think when you're...
This isn't the only evidence in the case against defendant. Basically, the crime is on videotape, isn't it?
That's correct. And that's why we also think that in any event, the error was harmless because we saw the jury during deliberations and
that evidence could be received during a trial, but that's not the issue. The issue is whether this witness should be permitted to testify as an independent source for the identification based on her 2 to 3 second observation. That's the issue, not whether there's additional evidence.
Well, Your Honor, I think there are two issues. First is the propriety of the independent source issue, or independent source ruling.
I mean, even if that ruling was erroneous, there's still harmless error analysis possible here, isn't there?
Yes, Your Honor, and that's what I think the second issue is. So there's both the propriety of the ruling as well as whether it was harmless. So to speak to harmless error, I do think we saw the jury request 3 different times to look at these videos frame by frame, passing around defendant's mugshot. When the court didn't let them take a laptop to deliberate, they sent a note that said this is critical evidence without which we cannot determine whether or not defendant is guilty or innocent. So I think that shows that the jury made up their minds based on the video, and whether Ms. Ledoux identified defendant or trial it not wouldn't have changed that fact. That's a degree of precociousness that I think renders any identification by Ms. Ledoux harmless. But again, I think People v. Williams, this court has said that a matter of seconds is sufficient. I think it's worth noting that not only did the witness remember defendant's face, but we corroborated that 11 days later when she identified him in an unsuggestive photo array. So that shows that she did see him and did.
That was after she had reviewed the video.
That's correct. She had seen
So the fact that she picks him out of a photo array after having looked at the video in the store, that to me is not real strong.
I think it is uncontested that the photo array was populated with people who looked like defendant. Your Honors have the video. I don't think it's a crystal clear video by which someone who views it one single time could then identify defendant in particular among the people in the photo array. So it's not dispositive for sure, but I do think it corroborates her credible testimony that she remembered it. As to that point, I think it's also worth noting that she did testify, that she got a better look at him in person than she did on the video. So I think that issue is kind of belied by her own testimony. And then again, just to return to Justice Friedman's point, I do think regardless of whether or not the ruling was proper, which again, I believe it was harmless because the jury clearly had their mind made up by what they could see and the comparisons that they made frame by frame to defendant's mugshot.
Thank you.
Your Honors have no further questions. We ask that you affirm.
The people's harmless error argument is disingenuous because they called a police officer to identify my client from the video, and they argue that that was necessary because the jury needed that assistance from the police officer to make that identification. So on the one hand, they're saying that the videos make it harmless. On the other hand, they're saying they needed a police officer to say, I recognize.
But doesn't the fact that the jury requested that video footage repeatedly belie that argument?
Not at all, just the opposite. That they repeatedly asked to see it meant that they were challenged by it and were...
Or confirming for themselves.
So it has two interpretations.
Okay.
It certainly doesn't make it harmless that they asked for it. I would say it makes it harmful. Is there another argument that could be made that it was harmless? Yes, but it doesn't rule out one or the other.
Thank you. Madison Hospitality versus Acasia Network. You may proceed.
Good afternoon. May it please the court. My name is Robert Kaplan. I represent the appellant Mave Hotel Investors, LLC. As described at length in the briefs, appellant entered into a memorandum of understanding with respondent, pursuant to which respondent, a nonprofit funded by the City of New York, used all of the rooms at appellant's hotel for transitional housing for homeless families. The issue presented by this appeal is what recovery appellant may pursue for the damage to appellant's hotel that was left behind by respondent's clients. There are two separate provisions in the MOU.
It's whether you have a cause of action for indemnification, isn't it?
Yes, Your Honor. Yes. So there are two separate provisions in the MOU which address what
Because in the memorandum of understanding, there are provisions which deal with indemnification, and then there's a provision, I think it's section 11, isn't it, which deals with damages.
Yes, Your Honor.
And doesn't what you're seeking to recover seem to fall under section 11 rather than section 13?
No, Your Honor, because the indemnity applies to, quote, any and all costs, expenses, claims, and liabilities arising out of the use of the hotel by respondents and its clients. And the property damage to the hotel is certainly a cost and expense arising out of the use of the hotel by respondent and its clients.
So if that's what 11 means, why do we have 13 as a separate
I'd be
clause?
happy to address paragraph
do.
11, Your Honor, because paragraph 11, as described in our brief, is unenforceable and should be severed from the MOU. That paragraph is unenforceable because any promise by respondent contained in that paragraph is illusory, and because respondent never intended to comply with that paragraph, and in fact, did not comply with that paragraph. A contractual provision is void when one party to a contract does not bind itself to actually do anything. Here, paragraph 11 of the MOU did not bind respondent to actually respond appellant for anything. Respondent has admitted over and over again in this litigation that under paragraph 11, a condition precedent to any recovery by appellant for damage to the hotel is approval of any claims for damages by the City of New York. Thus, by respondent's own admission, there's no enforceable promise by respondent to reimburse appellant for anything. Instead, there is only a conditional promise which hinges on a decision of a non-party to the MOU, the City of New York, but as described in our papers, the city is not actually obliged to do anything. Appellant cannot compel the city to do anything, and appellant has no remedy against the city. Indeed, in this litigation, the city has expressly avowed that it is not bound by paragraph 11 of the MOU because it was not a party to the MOU. A promise is illusory when in effect the promisor can say, I will if I want to. Here, the MOU provides an even more extreme example of an illusory, unenforceable promise, as it entitles respondent to say, I will if the city wants to, but there's nothing which obligates the city to do anything. And this unenforceable paragraph 11 should be severed pursuant to severability clause in paragraph 18 of the MOU. In addition, as described in our papers, a party cannot enforce a contractual provision if that party has itself breached that contractual provision. Respondent, because of its own breaches of the MOU, is precluded from claiming that paragraph 11 controls any claim for damages by appellant. Respondent never intended to comply with this paragraph and never complied with those paragraphs. Under the text of paragraph 11, respondent is liable for the costs of repairing damage to the hotel attributable to, quote, willful misconduct or negligence, close quote, of its clients. However, the employee of a respondent who is delegated with the responsibility.
So why isn't respondent bound by paragraph 11?
because it's an illusory promise, number one, and number two, because it never intended to comply with that provision, and it did not comply with the provision. So it's breaching the very provision that it now professes to rely upon. So.
Well, they can say we're not bound by it, but what's to stop you from saying, yes, you are bound by it, and we're going to sue you for it?
Is it your position that, because, I mean, it starts out by saying that Acasia will be responsible for any extraordinary damages caused by willful misconduct and negligence, and then it goes on. Is it your position that because the documentation, the documented damages will be reimbursed by the city? Is that, and so there's no guarantee that the city will pay anything?
There's no guarantee the city has to do anything.
Well, the city was not a party to this.
Right, it's not a part of the contract. So you have reimbursement under this contract that depends on the action of a third party that's not a party to the contract. It's a well-settled law. The city cannot be responsible.
And was an aspect of the contract that your clients were fully aware of when they entered into the contract.
Oh, Your Honor.
Am I right?
Excuse me, Your Honor?
Am I correct?
You are correct. My client signed it. However, in every case where there's an illusory promise, the parties have, it arises out of an actual agreement.
Yes, but it's not like this is a one-standing agreement that Acasia has with the city, right?
No.
There are multiple agreements.
I assume so.
And I
We're
would
not party to
suspect
anything.
that, okay.
We're not party to anything.
Why would they have to pay, who's paying the indemnification?
That the respondent has agreed to undertake expressly. They don't claim, there's no claim that the city, that they've not claimed they're not responsible under the indemnification if the city doesn't say so. That provision does not hinge on any approval by the city. That is a promise that respondent undertook without qualification.
Thank you. You'll have time on rebuttal.
Thank you, Your Honors.
This is a contract prepared by the city of New York for which our client was the agent. It's a not-for-profit.
Well, counsel, I mean, to be fair, in that last part where it does say that reimbursement for documented damages will be considered on a quarterly basis by the city of New York, how does that guarantee that they're going to get any money?
The way this was supposed to work, and it didn't work because our client says, and it's in the massive papers below, that it didn't always receive information from the hotel as to damages, was that the housekeepers were supposed to report damage, they were supposed to be notified, and we
Right, I understand that.
And
No,
there was
hold on.
I'm sorry.
The start of that paragraph 11 does talk about that the hotel will provide the documentation, but then even if that documentation, I understand that your argument is that it wasn't provided and that's a reason for non-payment, but even if it was, the city is bound to pay for those damages. What if the city says we're not doing it?
Oh, I don't know what the city is taking its position. Our client is the agent of the city. It did what it was supposed to do in the premises, and we have a litigation where we've had 3 summary judgment motions to deal with. This is ridiculous, actually.
Mr. Gruber,
yeah.
Let's go back a little bit.
Let's go.
Under this contract, or MOU, the hotel was responsible for repairs.
Absolutely.
That's paragraph 9, correct?
Absolutely.
So they had the ability to housekeeping to go in there, inspect, and do whatever needed to be done, correct?
Absolutely.
And so they're resting on the Chicago photographs as their claim for extraordinary repairs are.
Yes, and Judge Bannon said there's an issue of fact. We're not arguing on that.
Okay, and this case isn't gone. They have sued your client for breach of contract.
That is correct.
And that's still alive and well today.
There are damage claims still alive and viable. This whole notion that paragraph 11 is illusory, let me address that quickly. I've looked at the complaint. I don't see anything here looking to either reform or rescind this memorandum of understanding. Little too late to be complaining about that now, especially on the 3rd summary judgment motion. Fact of the matter is that prior to the client, our client entering into an operation in the premises, the record suggests that the premises were used used for this similar purpose before by a different operator. There were appraisals done in connection with other litigation and other matters, and one before our client said that the hotel, well, the owners haven't been investing in it, and they...
Well, that's the lost revenue issue.
That's the lost revenue issue, but
Which
that's
is
key here.
arguably not
The city of New York
included in
paid them
the
$5 million
Counsel,
a year here.
counsel,
I'm sorry.
when one of my colleagues are talking, please
You're right, you're right.
give them the respect and
You're right.
courtesy of your ear.
You're right.
Go ahead.
So fair enough. So the lost revenue issue is something that may not be shoehorned into the damages provision.
No, it can't.
Correct. Fair enough.
Fair enough.
And moreover, they have a claim for an account stated, but right now it's an open issue of fact. That's not gone either.
Correct.
And finally, there is a third-party complaint here, correct?
There was the city dismissed, it was dismissed.
Oh, it was dismissed.
It was dismissed, yes. That's not an issue at this moment. The fact of the matter is that there's a specific provision in this contract dealing with damages, and the contract law of the state has always been, when you have a specific provision, you don't look to the general. He can have his day in court on the damages. Hopefully it won't be the fourth summary judgment motion. But what basically here is, our client honestly believes that they're looking to it and indirectly the city of New York, because one suspects that whatever the arrangement is that if the city of New York wants Acasia to continue performing services like this, it's not going to leave them holding the bag. I think that's a practical reality that I think we all understand. The fact of the matter is, we did not undertake, nor the city nor the taxpayers of the city of New York, who ultimately is the responsibility here, did not undertake to give these people a new hotel. Judge Bannon got it right. She should be affirmed.
Thank you.
I'll be very brief. Noticeably absent from the argument for respondent was really addressing any of the real legal issues here. With regard to his claim that it's somehow we are foreclosed from raising the issue that the paragraph 11 is an illusory promise, it was raised below. This respondent said nothing about it below. They said nothing, and they said nothing about it in their brief here. So it's a little too late for them to be making that argument. Second, with regard to his claim about the specific controls of the general, that is the general principle of law. However, here the paragraph 11 is unenforceable, so it falls out of the contract. So the only thing that's left is the indemnity. Thank you.
Thank you. People versus Christopher Maldonado. May proceed.
May it please the court, Matthew Bova for Mr. Maldonado. First, Mr. Maldonado has standing to challenge the unconstitutionality of the licensing provisions that harmed him and directly applied to him, because any application would have been futile. This is this court's decision in Archibald. It's also this court's decision in Bilardo, the Second Circuit's decision to Castro.
Was the futility argument raised below?
So
the particular argument that because of your client's age at the time, he couldn't apply for a license, did you raise that specific argument below?
The defense's opening papers did not. The prosecution then spent about 3 pages with a head note in their papers saying, Mr. Maldonado has no right under the Second Amendment to possess a firearm because he is 19 at the time of the act. The prosecution directly injected this pure question of law into this case. It should not be heard now to make any argument about preservation, because clearly it was on notice and the issue was before the court. Preservation is about notice. To apply it in a situation where a party makes a pure legal argument in a case like this would elevate form over substance and make preservation the kind of technicality that the Court of Appeals has said it should not be. It's also really important that there was no prejudice here. This is a pure question of law. So the prosecution was not deprived in any way of making a record, and it would be pretty odd for them to suggest otherwise, given that they made the argument.
Did the defendant at the time, once the prosecution raised that issue in their opposition, was that in your reply papers? Was it addressed in the reply papers?
No, there was no reply filed.
And the court didn't address it in the decision either, correct?
No, the court did not specifically address age. But the point is that the issue was presented, everyone was on notice, and it was before the court.
Yeah, but the defense didn't even respond. So how can you say that you preserved that issue? The issue was, I think you are correct that since the people raised it, had you responded to it, you'd have a stronger argument. I suggest you move on.
So as to the standing question, there was futility here because of the age restriction. The age restriction categorically bars under New York Penal Law, Section 400.00, categorically bars someone under the age of 21 from seeking life.
But there's an exception there. It's not a complete ban because there's an exception for military members, right?
Yes, there's an exception for that, but the record clearly indicates that that's not the case. There's absolutely no reference to military.
Right, but we're not talking about the record here. You're saying that the statute itself, right?
Yes.
But the statute makes for that exception.
But it's futile for someone who is not honorably discharged from the military, and there's absolutely no record support for the suggestion that Mr. Maldonado, by the age of 19, somehow managed to have pulled off an honorable discharge once he turned 19. That argument is also directly contradicted by the prosecution's own argument below, because they specifically argued that he was not entitled to possess a firearm under the age restriction. Given that he has standing, this court should hold that the youth restriction finds no historical tradition in the American national tradition, and therefore under Bruin is unconstitutional. The prosecution hasn't identified a single piece of evidence, either at the time of the ratification of the Bill of Rights, at the time of the ratification of the 14th Amendment, that establishes a historical tradition of categorically disarming people under the age of 21.
Counsel, let's not go there. Let's not go there, because we know that this amendment, when written, we were in a different time historically in this country, okay? So when the gun laws back then were enacted, we were talking about muskets, not the semi-automatic pistol that your client was found holding.
Well, but Bruin holds that we don't update the Constitution to comply with modern political beliefs. And more importantly, I mean, this statement—
That's not a political belief. That is a factual statement, what I just said, not a political statement. Our country, when these statutes were enacted, was in a different place. I'm sure even you could agree with that.
But under that theory, well, it was different, but there was no historical tradition of drawing a distinction between a pistol and a semi-automatic firearm.
Because there was no semi-automatic pistol then. Let's not have a pretend conversation. I am more than happy to listen to your proper legal arguments, but we're not going to play factual pretend in this courtroom, okay? There were no semi-automatics when these the Second Amendment was enacted.
But that is, yes, Your Honor, but that is an argument that the prosecution hasn't even made. The prosecution isn't making an argument that there's somehow a distinction as far as 18 to 21 goes between semi-automatics and a revolver, and that argument would fly in the face of Bruin also.
I guess I'm a little bit concerned because post-Bruin, there has been, and even I think Bruin itself says that states are able to put certain restrictions on their gun licensing laws. They're not saying that everybody, babies, toddlers, anyone go get a gun. That's not what Bruin stands for. And so if, in fact, states are able to put these restrictions in their statutes when it comes to gun licensing, unless, as later case law that's even been interpreted by this court says, unless there's a complete ban, which brings me back to my point saying that the age restriction is not a complete ban because there are exceptions for people who are honorably discharged from the military. It's not a complete ban. I'm not necessarily understanding your argument of futility.
Well, it's a complete ban as to someone who does not have an honorable discharge. So Mr. Maldonado would have been engaging in a pure act of futility if he had made an application, because his application would have been instantly denied under the age restriction.
Okay, you have 1 minute on rebuttal.
Thank you.
Good afternoon. ADA Nicole Nichols for the Office of Darcel D. Clark. May it please the court. Defendant's appeal should be denied for 4 reasons. 1, his Second Amendment challenge is barred by his valid waiver of the right to appeal. 2, he lacks standing to bring this claim. 3, his specific claim.
Counsel, why don't you focus your argument on the futility part? That's where he spent most of his time.
Your Honor, as to the futility, the defendant never raised the age issue below. It was while the prosecution brought it up as a general response to his general claim that Bruin barred, that Bruin now permits everyone to possess a gun. The prosecution did argue that his age barred him. Defense had an opportunity to submit a reply. They did not. The court decision makes clear that this issue that defendant is arguing for the first time on appeal was not brought to his attention. The court's decision makes no discussion.
Well, it was brought to his attention by the people. The court didn't focus on it in its decision, but it was brought to the court's attention.
That is correct, but for preservation, Your Honor, CPL 47005 directs that for the protest has to be registered by the party claiming error. And the party claiming error here is defendant. So defendant did not make that protest, so he did not preserve it. The second way he can preserve it is if the court, in its decision, recognized it and addressed it. And here we're saying the court did not. And you reviewing the decision makes that abundantly clear that that issue was never brought to the court's attention.
Notwithstanding all of that, even if I agree with everything you just said,
Yes.
why is he still wrong?
Your Honor, he's wrong because Bruin just does not stand for what he claims it stands for. Bruin does not invalidate, the Supreme Court made clear that limits can be placed on that Second Amendment right. It made clear that Justice Alito in his concurrence indicated that Bruin did not expand the categories of people that could lawfully possess a gun. That it recognized that the 43 states that have the shall issue licenses regime, that those were perfectly appropriate. That states are allowed to make reasonable limitations on citizens' ability to possess a gun. And here the age limitation is reasonable and is historically based. Defense counsel submitted some additional documentation to the court. I anticipate that on rebuttal, he'll argue that those documents show that there's no historical basis because the age restriction statute came into effect recently. But if you look at the notation, the comments to the statute, it indicated that this was merely codifying a practice that was in existence, that licenses was not being given to individuals who were under the age of 21, and they merely made that into a statute. So
and ironically, oftentimes on youthful offenders, we hear how young people under the age of 21 don't have full control of their faculties. They're not, they haven't reached proper maturity and proper judgment, but let's give them all a gun.
Exactly, Your Honor. And so we would say that there's a reasonable basis for the age limitation, that it's permissible on the Supreme Court's decision in Bruin to place such a limitation on the right to the license. For those reasons, we ask that the court's decision be affirmed.
Thank you. You have 1 minute.
But we don't need to rely on New York's tradition, which really shows that there is a tradition of not categorically disarming people between the ages of 18 and 21. We just have to look at the national tradition, too. The Eighth Circuit's decision, the Third Circuit's decision make very clear, this is basically uncontested, that there is no historical analog of disarming individuals who are of military age service over the age of 18 and just before the age of 21. Now, as to New York law in 2000, for the first time, imposed an age restriction, and in the governor's memorandum, specifically notes that there had been a practice at the licensing level, at the discretionary level, of barring license to those under the age of 18, but not those over the age of 18. That's our argument. It's not about 17-year-olds. It's not about 16-year-olds. 18 is the key age because it was the age of required military service at the time of the founding. You can currently be required to bear arms by the government here and sent over abroad to potentially die during a war. All we're saying here is that tradition establishes also that an individual who is at the age of 18 has the right at a minimum to make an application and not be categorically cut off by a restriction.
Thank you.
Thank you.
People versus Jones. You may proceed.
On behalf of appellant Mr. Jones, Daniel Hamburg with the Center for Appellate Litigation, Mr. Jones's sentence should be reduced to a conditional discharge or time served because his sentence of probation is excessive in view of his history, character, and condition, and the specific nature and circumstances of his offense. Furthermore, his claim is not precluded by his waiver of the right to appeal. The Court of Appeals has held that a minimum sentence consistent with the goals of societal protection, rehabilitation.
Is it your view, in the absence of a criminal history here, that your client, who showed an utter lapse of judgment in walking in with his friend with a loaded firearm and a bottle of tequila, that suggests that he did no need of any kind of supervision? I mean, how does probation under these circumstances, which was agreed to, affect his life? I mean, he can still be gainfully employed. He just has to show up at, say, what, once a year or something along those lines?
Well, courts have held that probation does entail a substantial curtailment of liberty, and it can often be the vast majority of probation violations are for technical violations, and that it can lead to incarceration. So I don't think that it's fair to say that a sentence of probation has no impact on Mr. Jones's life. It also...
I don't think that's what my colleague said. What my colleague said is, what is so onerous about having to report to a probation officer when you showed such lack of judgment that you would have a 9mm pistol while hanging out on a corner drinking tequila with a bunch of guys? That is the recipe for something to go wrong real fast. All it takes is one stupid comment, one ridiculous affront for that to go terribly wrong. So why is this so offensive that he should have to serve 3 years probation?
Your Honor, I'm not disputing that my client had a lapse of judgment.
Again, why is 3 years probation so offensive to someone who showed such utter lack of judgment?
Under these circumstances, Your Honor, where an otherwise law-abiding citizen like this, who purchased, without dispute, purchased the firearm legally in another jurisdiction...
Well, but the people point out that there's no proof of that.
It was undisputed below.
Was there proof? It's only undisputed if there was proof before the court that he actually purchased it legally. And I see nothing in the record to say that, other than him saying so.
Well, in the state of North Carolina...
Counsel? I know about North Carolina. I have friends there too. There's no evidence in the record.
Your Honor...
Unless I missed it, tell me what page it's on, and then I apologize.
Your Honor, I don't have affirmative evidence, but I can say that under the...
And the people do challenge to point out the lack of evidence of this.
I don't believe that the people challenge that Mr.
I don't know that
Jones
they're
was...
challenging it. They say there's no proof that he, in fact, legally owned this gun in North Carolina.
And I'm sure that since your client used to live in New York, does your client say that he was unaware that he had some information that New York had changed its laws?
Your Honor...
He lived here. He knew that you can't possess a gun in New York without a New York license.
Your Honor, my client had been...
And there's no question he was in New York for at least a year when this happened.
I believe that the record is not entirely clear on how long Mr. Jones had been here prior to this first and only contact with the criminal justice system. He said he had been here since coronavirus had ended. As you know, this court pointed out earlier, we're still living in
coronavirus has ended,
coronavirus.
so I'm not sure when that was, but you'll have time on rebuttal. You may proceed.
Good afternoon, Your Honors. Elizabeth Schmidt for the people. May it please the court. I'm mostly going to echo what Your Honors have already observed. A 3-year term of probation here is absolutely appropriate considering the conduct. to briefly note that defendant was in New York and by his own statements living in New York for at least a year. Not only did he say, I've been back since coronavirus ended, he also said, I've been back a year. In addition, he also listed a New York City address as his permanent address. So he's been in New York for at least a year by his own admission. He knows the rules. Even if he had just been visiting, he's still under the obligation to act lawfully.
We're not talking about someone who took a trip here from North Carolina, doesn't realize that the law may be different here.
No, Your Honor. I mean, regardless, you're under the obligation to follow the laws of the state in which you're present.
Even if you did take a trip and you're right, you're supposed to know the laws of the state. But to the extent the defense counsel points to, well, it was legal in North Carolina, he's been here in New York for a while and should have known that you needed a license here.
That's correct, Your Honor. He knows what he needs to do here. He knows how he needs to comport himself. What he did was extraordinarily reckless, to say the least. And so a 3-year probationary term, which was the absolute minimum here, is correct.
Thank you.
Thank you.
I have nothing to add.
Thank you. The Board of Managers of Cipriani versus Howard Zimmerman Architects.
This involves gun licenses, we're all in trouble.
May I proceed?
You may proceed.
May it please the court, my name is Brian Waller, and I represent the plaintiff appellant in this matter. The court below erred by dismissing the complaint against defendant Howard Zimmerman. The lower court's decision was incorrect in 2 distinct ways. First, with respect to the accrual date of the statute of limitations.
Sir, on this record, as I understand it, Mr. Zimmerman played 2 different roles in 2 discrete periods of time. In the earlier phase, he was an agent for the condominium, arguably supervising Millennium's work and signing off on those invoices. The last invoice, which I believe is October 2016, correct?
That's correct.
Okay, and then after they terminated Millennium, he took on a different hat as the actual architect of record with his company to actually complete the plans on the cogeneration plan and all that other stuff that they paid millions of dollars, that your client paid millions of dollars for, correct? So as I see it, and since you're arguing architect malpractice, that's a 3-year statute of limitations, you don't dispute that. So as I see it, when there's a discrete break in the role and responsibility of a particular defendant, as in this case, tell me how you could possibly argue the continuation of services that would allow you to have the statute of limitation keep on running.
Well, first of all, there wasn't a change in his. There was an addition of his scope, right? In 2017, he took on additional scope.
He took over the contractor that your client was unsatisfied with, legitimately so. Okay, so he took over their work. So it was different work.
Well, okay, so he took it over, though, in an effort to remedy the damage that had been caused by the contractor who he was supposed to supervise.
Right.
That's one.
In the cases where we have found such continuity, it's either been the same kind of work or they're the ones who committed that work. And you don't have that either. You don't have either one of those here.
Well, I disagree with that because although one part of the scope of work in the original agreement was to supervise Millennium, which was the contractor, it was also to provide architectural consulting services and engineering services to complete the project.
No, wait.
That's it.
No, his job was to oversee the contractor that you hired, right? To make sure that whatever the plans were appropriate, etc. So his job was to make sure that the invoices were correct, that the work that they claimed to be doing was being done so that your people could pay the bill when due, right? And then when Millennium, the contract the company that you hired to do that work failed to do that work promptly or on time, whichever way you want to describe it, you then hired the agent that you had overseeing the first architect to now take over the architectural work.
That is true, and it was done through an addendum, which expanded the scope.
As opposed to a completely separate agreement.
Correct. It didn't supersede the contract. It wasn't a
But
new
you
contract.
call it an addendum as though that somehow allows you to piggyback a different function in order to have the continuous doctrine.
Well, I would direct the court to your decision in IFD Construction Corps versus Cordry, Carpenter, Dietz, and Zach, which is cited prominently in our brief, and it's addressed. And the issue here is you're looking at accrual for Mr. Zimmerman as it being the last incident or the last event that he performed something that we've alleged in the complaint was malpractice. But under IFD Construction Corps, that makes a distinction between when the accrual date actually accrues. And that case makes clear that where the claim is made by a party who had a professional relationship with the architect, as was the case here, such accrual runs not from the last incident,
And
but from when the
when
relationship
you say
ends.
a professional relationship, in IDF, was that professional relationship as an agent to the owner?
It was to provide architectural
But that's not what his job was in phase one. His job was to oversee
phase
the architect.
I know that opposing counsel has characterized this as phase one and phase two, but that's not really what happened. Phase one.
Was phase two intended when you started?
I don't even know what phase two
Phase two, what, did your client intend to hire a second architect at the beginning of this?
No,
No,
but it's
right?
not-
They intended that the project be finished with the first architect that they hired, correct?
That was their hope.
Of course, and I would hope the same thing if I were in their shoes.
Right.
Right? That didn't happen right. It didn't turn out the way they wanted it.
not.
And now they have to regroup in order to finish the job. And they hire their agent, who is a skilled architect, to do that job.
To do part of that job. Yes.
To complete it, to complete what
That's
the first
correct.
guy
But
didn't
it's
do,
not-
right?
But it's not a different phase of the project. And the cases that we've cited in our brief talk about that.
But it's different work.
It's additional work.
Different row.
It's not completely different work.
Counsel, I mean, I like, just based upon your own complaint and the way that you've laid out your allegations, when you talk about this individual defendant, Zimmerman, I think it's his mentioned individually in, paragraph 30 and paragraph 42, all four events occurring before October 2016. What in your complaint would now go beyond that as to this individual defendant?
Well, part of the negligent misrepresentation claim was not just the representations about certifying the work that Millennium billed for. It was also that he and his firm were qualified to do this work, and they clearly weren't. Right, and then he took over this role to try to remedy the situation that occurred with Millennium. But
he took over this role because your client hired him.
Correct.
So you can't say on one side he clearly was not qualified to oversee, and then you hire him to do the job. There's like a serious inconsistency in those two positions.
Right, but the case law also makes a distinction about the reason why so the continuous representation doctrine, which we are relying on and the court below rejected. The purpose of that is so that we don't have a position where someone like my client has to now sue their architect in the middle of a project. So the case law says that when you have, even if there's multiple agreements, even like my argument is that there's not multiple agreements, it was an addendum to an original agreement, but even if there are multiple agreements, the continuous representation looks at what the work was related to, not the scope of work being done by the architect, but the work that it related to, which in this case is the project of installing the cogeneration system.
So you're saying if this defendant, if his only job was to collect a check from your client and take it to the architect, and this same thing happened, that was still the same scope of work? That those things are related?
But that's not the case here. The work,
It's not too far off.
their job was to make sure that the work got done and got done correctly. So the cases clearly say that, especially when you have a professional relationship, right? The retainer, my client retained Zimmerman.
See, I don't disagree with you that there would have been a viable claim against this defendant for the very claims you are asserting, had you done so in a more timely fashion.
Right, but then that would...
So you are dependent on the continuous representation doctrine to get you there. And we are suggesting by our questioning that there seems to be two different scopes of work. And we're not sure how those two fit into one continuous.
But the intent of all that work was to install the renovation of the cogeneration plant. And if what you're suggesting is that my client should have sued the architect while the project was still going on, which puts my client in a completely untenable position. And I'm not making that up. That's in the case law that we've cited. That's the reason why you have this continuous representation doctrine, so that
I'm not sure why the first go-to is to sue Zimmerman as opposed to the people who are doing a bad job.
because those people, I believe, are out of business. Okay, so that's one thing, but that's part of it.
Aha, okay.
But there's still a malpractice.
Right.
And
Counsel, I'm sorry if I'm missing something. One final point for me. The case isn't over. You have a breach of contract claim against Zimmerman's architectural firm that's alive and well.
That's correct.
Okay, which means that all the breaches of that contract and all the damages that you claim were done because they didn't do the oversight you asked them to do, their phrase, phase one, not yours. And as was pointed out by my colleague, there's no allegation that Zimmerman messed up after October 2016 in terms of professional negligence or professional misrepresentation. There may be breaches of contract as to the scope of work because the contract got scaled down. I mean, the project got scaled down. They had to spend more money than they should and all that other stuff. I'm not making light of it.
Yeah.
But your breach of contract claim against this firm is alive and well.
That is true.
And you'll be able to throw in all the damages that flow from all the phases based on a 6-year statute of limitations, correct?
That is true.
Okay.
But from our perspective, that doesn't mean that we shouldn't also,
No, I
we shouldn't
understand.
individually also have liability.
Okay.
But you're right, we're not, our case isn't
Over, right.
Isn't over. That's
And you'll have time on rebuttal.
Thank you, Your Honor.
May I proceed, Your Honor?
Yes.
May it please the court, Adam Felsenstein, Tannenbaum, Halpern, Syracuse, and Hirschritt for the respondent, Howard Zimmerman. I don't want to belabor a lot of the points that you've recognized, and I was going to open by saying that this case goes on regardless of how you rule. But what appellant is arguing is that he should be allowed to bring claims against Mr. Zimmerman personally for representations and actions taken in 2016 as an owner's rep, using doctrine and precedent that really applies to architects as design professionals. And I think there's a couple of facts and points that I'd like to address from my opposing counsel's argument. The first is, it's buried in the complaint, but you can find it on page 27 of the record. Appellant went and hired another owner's rep when the Zimmerman firm took over as architect of record. And that should very clearly indicate how separate and different the roles were. They went and replaced Zimmerman. With regard to the negligent misrepresentation.
Well, I mean, you wouldn't expect Zimmerman can't oversee itself. So it would make sense that they might find somebody else as their representative to now oversee the new person, the new firm.
Of course. And that's beyond cavil, I think.
But your point is well taken. Obviously, they felt they needed a separate person to do that job.
Correct. That's because the jobs are so very different. The fact that they call it an addendum is really it's really just form over substance, just a title you put on a document. It's not really an addendum. It's an entirely different scope of services. One is design, and it's just for the purpose of clarity, Millennium was the design builder. They were the architects responsible for designing it and also for constructing it. Zimmerman personally and HLZAE, which is the firm, had no role to play in that particular part of the project other than overseeing the plans for feasibility. And I just want to also kind of note that supervision, we use the word supervise, it's a term of art in the construction industry, and supervision really means day-to-day sitting on the site, watching what they're doing. That's not what an owner's rep does, which is just to verify what the work is, make sure that it's the percentages of billing that they're doing is what's actually in place. I do want to address the negligent misrepresentation claims only with regard.
They're claiming, at least in part, that your representation, your oversight work was faulty because you said, oh, everything's going fine, they're doing everything they're supposed to be, and you can pay them $2 million today, when in fact, things were not going so well. And eventually they had to be thrown off the job, and you had they had to go and hire you, who they thought knew a little bit better about what was going on in the project, to do the work that they said was being done that wasn't being done. Is that not what happened here?
I'm not sure I understand the question, but to the extent that I do.
Look, there were times when Zimmerman said, oh, 71% is already complete, pay them.
Correct.
And then it wasn't 71% complete.
Yes, and I think I understand the question now. That's a breach of contract claim that the Board of Managers has against Zimmerman for work it did as the owner's rep.
Isn't that misrepresentation work, a misrepresentation claim also? You misrepresented to us. You were supposed to you were supposed to be the rep, and you were supposed to tell them everything's going fine, everything's not going fine. You said, yes, pay, everything's going fine, when in fact it wasn't. Isn't that a misrepresentation?
Without assuming that were true, without question. But I think I will hearken back to what Justice Manzanet said, which is that claim is stale. If it had been brought in 2019 and the representation in 2016, based on a representation in 2016, I wouldn't be standing here.
But then they hired you to take over the work, and then you were continuing to work with them. It's hard to, they didn't, what they're saying is they didn't want to sue you while you were completing the project. And that's the whole continuous representation concept about extending the statute of limitations.
Absolutely. And I think what is making everybody on this bench and myself a little uncomfortable is you're trying to apply architectural theories and architectural case law to what is not, in fact, an architect's job. They were doing a different job, and it's not controlled by the same doctrine and the same case law. And that's really what IFD in all of these cases hold. They really hold that you have a continuous scope of services. And IFD in particular is a negligent misrepresentation case, and it's actually a negligent misrepresentation case brought by a contractor, not an owner, against an engineer. Because what happened in IFD, and it's kind of an interesting case, is the engineer went and said, I'm gonna go examine the soil, there's no contamination in the soil. The contractor went and then based his bid on that representation. Later, it found soil contamination and said, well, my bid was all off, I've way underbid the project, and now I'm harmed. And in dicta, what the court said, because it said sometimes unspecified claims by an owner against an architect accrue when the architect finishes the job. All about architects, what architects do, what design professionals do. That's not the role that Zimmerman was playing here. He wasn't, and just to kind of round out my thinking, I'm doing this a little off the cuff. The continuous representation doctrine, one of the reasons that you want it needs to be the same scope of services is the idea is that the professional is gonna correct what it did in later, to give that professional the opportunity to remediate its own problem. Here, the problems that Zimmerman was remediating were not of its making, assuming there were problems at all.
But
no one is saying that.
But it wasn't like it had nothing to do with it. I mean, he was overseeing, and you wouldn't have hired a mechanic to oversee the architectural work that another architecture was doing. You hired an architect as your representative to make sure the work was being done properly.
Within a very limited scope, and not necessarily as an architect. There are many owner's reps who are not architects. You do not have to be a licensed architect to be an owner's rep. And there's a very limited scope of services. And part of the issue here is the contract is not part of the record. That was not, we're dealing with what the allegations are as put in the complaint. And those allegations just don't amount to negligent misrepresentation by an architect about architectural matters or architectural malpractice, which runs totally unspecified. And if the court wants, I can address the malpractice claims, but I'm out of time.
Got it. Thank you.
Thank
so
you.
much. You have 2 minutes on reply.
I just want to go back to the IFD case because I think it is an important case. I think the IFD case is significant because it draws a distinction between a malpractice case or a negligence case brought by a contractor who's outside of the professional relationship, which is not the case with my client, versus a situation where there is a direct professional relationship between the parties. In that case, so where it's an outside contractor who's not part of the professional relationship, then the statute of limitations starts to accrue from the last time there was an action that that contractor relied upon, which is exactly what my adversary said. Here, though, there was a professional relationship, whereas my client specifically retained Zimmerman. And in those situations, IFD or IDF, I think it's IFD, makes clear that the statute does not accrue at the time, the last incident of a malpractice, but at the end of the relationship. And the case law also says that the end of the relationship comes at the end of the project, at the end of the work, aside from small ministerial punch lists, things like that. So that case specifically says.
But isn't that case law for the party actually doing the work? The punch list is not done by the agent's rep. The punch list is done by the contractor. So the case law you're referring to would be applicable to Millennium.
It's not, though. It specifically talks about a professional design relationship, which is here.
But he was not hired as a designer. He was not hired as an architect to design the project.
But he was hired as
to oversee it, to be the agent, right?
He was hired as a design professional to oversee that work because of their expertise. So they were relying on their expertise as a design professional.
So you now want us to have case law that says that an agent of an owner for a project who oversees an architect is responsible for the architect's negligence. That's really what you're saying. So if the architect you hire messes up and I'm the agent who oversees that architect, I'm responsible now for his mess up too.
My point has nothing to do with responsibility. It has to simply do with the accrual of the statute of limitations. So there may be other reasons why we don't prevail on our claim, but it shouldn't have been dismissed for the statute of limitations argument.
Okay, thank you.
Thank you.
Fredman versus Bloomberg. You have 6 minutes and you may proceed.
Yeah, thank you, Your Honor. May it please the court, David Garland of Epstein, Becker, and Green on behalf of the appellant Bloomberg. And where I'd like to begin my 6 minutes is focusing on the key errors that I think were made below and point out what I would submit are the undisputed facts of record that supported the entry of summary judgment. And I want to begin with where the lower court said that there was an issue as to when the decision to terminate this part-time assignment was made. It's undisputed in this record when that decision was made. and that decision was made on November 24 of 2020.
And didn't this plaintiff inform the defendants of the difficulty of her new assignment because of her disability with dyslexia prior to that November date?
So what the record shows, Your Honor, on that point is that she she expressly refused and objected to performing.
No, that's not my question.
No, but I'm getting to the answer.
I need you to answer my question.
And I'm trying, Your Honor.
Please answer my question.
So
Did she not notify her supervisors that prior to November, when you say this decision to fire her was made, that her new assignment as to create copy for someone with dyslexia, right? And she said she needed an accommodation. She would require a proofreader.
Actually, Your Honor, I would submit that's not what the record shows.
That's what the record shows, but you go ahead.
So, Your Honor, again, what her testimony is that she had anxiety in performing that role. She did mention dyslexia. She didn't say her dyslexia.
Prior to the change of her role, she was a great employee, had received great recommendations. Her assessments were wonderful. And then her role is changed.
So
without consultation, they changed the role, and she informs her new supervisor that she had concerns about this new assignment because she suffers from dyslexia, and to prepare copy would be difficult for her, and it was causing her anxiety.
Your Honor, I submit what her testimony was, that it was causing her anxiety. And Bloomberg then...
That's what I just said, but go ahead.
Well, I think there's a distinction, respectfully.
You want to quibble over what caused her anxiety. And I read the record too. And she said she suffers from anxiety, and her new assignment to create written copy caused her anxiety because she has dyslexia, and she wanted to make sure that she had someone who could proofread her work so that it could be done on a timely basis.
And then Bloomberg did engage in the cooperative dialogue with her.
What was that cooperative dialogue? Tell me, what did they say?
They offered to restructure the position to reduce the amount of time to do that. She actually agreed to try out doing that function using a grammatical checking software. She did do that. She accomplished it. And so again, I do think that
But as I understand it, several of her coworkers complained. So clearly that grammatical check thing wasn't good enough, and she asked for a proofreader.
So she did not ask for a proofreader, Your Honor, until...
She says that she asked for one. Is that not an issue of fact that would warrant the denial of a summary judgment?
It is not here, Your Honor, and the reason for that is that, one, she pleaded in her verified complaints, just not an unverified complaint, she pleaded that she made that request on December 1. That's why I started with the decision having been made on November 24. And there is extensive back and forth.
Was she aware, was she told that she was going to be terminated on November 24th?
She wasn't, but she didn't have to be told.
But the point is, you say we had already decided to terminate her, so when she asked in December, it doesn't count.
Well, that's right. And the case law is if the decision to terminate this part-time assignment was made before she made the request for accommodation, then the employer does not have an obligation at that point to engage in a cooperative dialogue because the decision's already been made. And we cited cases in our briefs for that very point. So that's why I started with when the decision was made. Also, I think perhaps the three most important words in this record, in my view, are the words, one more thought. And those words appear in her December 1 email. In that email, she says, after she had met with them, they had talked about her leaving. This was December 1, talked about her leaving, and she asked if she could stay on a bit longer because she wanted to, she was buying a second home. After
And
that
it was
meeting, she
right
wrote.
around Christmas time, but go ahead.
It was.
Yes.
Yes. She wrote one more thought. And what was the one more thought? That then she articulated in that same email. Could I have a proofreader?
But that wasn't the first time she mentioned it. It may be the first time she put it in the email, but that's not the first time she mentioned the need of a proofreader. But you'll be able to tell me all about that on rebuttal.
Thank you, Your Honor.
May it please the court. I just want to confirm that the plaintiff's testimony says she brought up dyslexia and the need for a proofreader from the start. And
There was a November 16th email where she indicated she had dyslexia?
actually, the November 16th email was from her supervisor talking to
Like when he was talking about what happened, I was just looking for that email.
Right. And there's, I'm sorry.
And she's, and he, Mr. Coughlin?
It's a woman, Kay Coughlin.
Excuse me, Ms. Coughlin indicated that, that she had mentioned, your client had mentioned that she had, that she had dyslexia, and that's why she was concerned about what she was going to do and was concerned of having anxiety over this new position. So she saw, this was certainly before that November 24th date, where you say that's when you started the process of terminating the plan.
Certainly, there was actually two emails that Ms. Coughlin sent to Human Resources, one on November 16th, and then the one on November 20th, where she said, I wanted to flag that during this conversation, Abby brought up having dyslexia as one of the reasons she didn't want to do this role. There's a timeline.
There was a meeting on November 13th or 14th, 2020, wasn't there, in which she told Kolarski that the role that Coughlin wanted her to undertake would interfere, would be difficult for her because of her disability?
Yes, she did. In fact, there's a timeline that defendants submitted in support of their motion. It's unclear who wrote it, but from the start in in August, it mentions Fredman informs Coughlin she will have anxiety because of dyslexia. There were multiple conversations about dyslexia. That is undisputed. What's disputed is what took place during those conversations.
So do you think, based upon the record as you're reading it, that there was this accommodation meeting that they had to see what they could do?
So from the start, she said, can I have someone help proofread, which was a common practice was said. And they said, well, try it out and let's see. There was two accommodations that were offered. One was, we'll have
when were these? After November 16th? Before? I'm trying to get the timeline of it.
One was November 13th. And then one is November 20th. So they're all very short. Neither one of them addressed the dyslexia. One was to help show her how to do the work, which she didn't need. The other one was to reduce the time, but none actually got to the heart of the needing a copywriter. I would note that on reply, defendants say that Ms. Fredman was offered a copywriter or was offered someone to help proofread, which is the first time in the record that it's ever been submitted. Some of the factual assertions by defendant are simply not credible and not supported by the record.
And the argument here was that because they had made a decision to terminate her in November, they didn't have to provide a proofreader.
Right, well, I want to sort of clarify what this means about the date. What they're really saying is that—
do you agree with that proposition that if they decided to terminate her, and then she tells them about dyslexia, they're not required to have this meeting and seek to accommodate?
If that was this fact, if that was this case, then yes. But here, from the start, from August, she was talking about dyslexia, about the need for a proofreader. What they're really trying to say is that she never even asked for an accommodation until December 1st. The problem is that they're saying they offered accommodations in November. How could they have offered accommodations if she never even told them about the need for an accommodation until December 1st? It's internally inconsistent. The lower court was correct to hold that questions of fact abound in this case.
In fact, on the November 16th email to Human Resources, Coughlin stated in that meeting that the plaintiff reacted negatively to copywriting editing, but was open to being trained to build campaigns, and explained that she had dyslexia and copy editing was not a strong suit. Coughlin also stated that she and plaintiff decided that plaintiff would try the new role with 2 colleagues supervising copy editing, not proofreading.
Right. And then there's this one more thought email that the plaintiff wrote that defendant makes much of. She wrote, could we have someone accommodate me? There's testimony that the decision was made, but it's not clear. The lower court found that there was a long delay. There were many deliberations. It was unclear if they were actually going to get rid of her because, yes, up until then, she'd been a great employee. Coughlin came in, her supervisor, Kolbarski, kept telling Abby Fredman, you're great, we're going to find a place for you. Coughlin didn't last very long at Bloomberg. She left shortly after a year. But when she said this one more thought, her testimony was that didn't really make much sense. I think she was just trying to be delicate. But the response to the one more thought email makes even less sense. The response was, given the needs of the team in this role and your mandate around your responsibilities, it makes the most sense to part ways at this time. If this is genuinely the first time they're ever hearing about an accommodation, to respond that she's making a mandate raises even more questions about what the intent of Bloomberg was. And this is under the city law. There's no requirement that the plaintiff prove that this was the only reason. She doesn't have to disprove the reasons that Bloomberg gave. In short, it takes a special kind of audacity to say that someone could look at these facts and only conclude what Bloomberg said was correct. And it takes an even more special type of audacity to say that the lower court should have agreed with Bloomberg's assessment of the facts of this case. The lower court should be affirmed and costs should be assessed.
Thank you.
Your Honor.
You have 2 minutes on reply.
Thank you again. Let me go back to what happened in that fall of 2020. There were some comments about her being a wonderful employee. That's not what's in the record. You've seen in the record how she referred to one of her colleagues at a meeting as an idiot, how going back even
Counsel,
before...
prior to this change of role, there was no negative statements about this plaintiff, okay? And disparaging her doesn't help you here.
I'm
so
not
why
trying
don't
to
we
disparage.
address the issues at
I'm not trying
bar?
to disparage, Your Honor. I'm just trying to focus on what is in the record. And I've heard my argument characterized as having a special kind of audacity. I'm trying to focus what's in the record and my understanding of what happened here. And here, there were issues with her performance earlier, and that's not disparagement. That's just trying to correct
Prior
the
to
record.
the change of role?
Prior to the change of role.
I saw nothing in the record
There's a
to
reference to
support
she
that.
had issues with communication and issues about her tone with her colleagues. That is there in the record. Now, there is, I submit, a distinction. Let me go back. There was a back and forth between Bloomberg and her when she raised the anxiety that she was having in performing in the new role.
In the record I read, the staff at Bloomberg kept saying, okay, we'll get back to you, and never got back to her.
You know, in the record, they did get back to her. They did offer her accommodations. They offered to restructure the role. They offered to get her assistance. She refused to do the role. And that's one of the interesting legal issues here as opposed to factual issues. When someone says, I refuse to do the role, and she also said, and she admitted, it's in the record, I'm not qualified for the role. It's her testimony, her words, that she said she wasn't qualified for the role. And if we accept those words and she's not qualified for the role, then she cannot pursue any of these discrimination claims because that's an essential element of a prima facie case. Thank you, Your Honor.
Thank you. Ciano versus Riverdale SNF. You may proceed.
Good afternoon, Your Honors, and may it please the Court. My name is Kristen Gianaros for the plaintiff appellant, Ms. Bertha Ciano. Contrary to the motion court's findings, the opinions of plaintiff's expert were neither speculative nor conclusory, and they were sufficient to raise triable issues of fact. For instance, although defendant's expert opined that it was perfectly reasonable to allow this 97-year-old resident to ambulate on the unit using a rolling walker, which is how she fell on the date of the accident, plaintiff's expert firmly disagreed and opined that this intervention was highly inappropriate and should have been removed and changed from her care plan. That opinion was
Especially in light of the fact that there had been falls prior to that, right? And the level of risk of falling had changed so often.
Correct.
And not one fall, not two falls.
13.
12 falls before this last fall.
Correct, Your Honor. And that's exactly what the expert's opinion was predicated on. She was having recurring numerous falls, and she has documented complaints in the record complaining specifically about a difficulty to ambulate and difficulty with having balance issues. In fact, as recently as 1 week before the accident, on October 8th of 2019, she made a complaint to a PT personnel at page 1762 of the record, specifically claiming that she had impaired standing balance and decreased gait activity tolerance. And yet 1 week later, that's exactly how she falls, walking with her rolling walker, lost her balance, and fell and broke her hip.
One of the things Dr. Steyer says is that there should have been 2 people dedicated to ambulating her. I mean, where does that sort of a requirement come from? I mean, any nursing facilities are having 2 people ambulating 1 patient?
That's an alternative to having her transport by wheelchair instead of rolling walker. And the expert opined that alternatively, that was another feasible and alternative available.
So it's either put her in a wheelchair or have 2 people
walking aside her with the rolling walker. And I just to that point, I'd
What's
highlight...
the basis of that standard of care of 2 people walking her?
The basis of that is actually in the defendant's own records. On her admission in April of 2017, that's how she was noted to require extensive assistance of 2 staff members. Somewhere along the line, I believe in September of 2017, that was changed to assistance of 1 staff member, which we submit was just highly inappropriate for this high fall risk, vulnerable patient.
But that decision, I'm sorry, but that decision was due to understaffing, presumably.
I'm sorry?
That decision was due to understaffing, which would seem to be acknowledged.
I believe that there was understaffing here, and that certainly would...
Well, that was what the observations, they were, in other words, the family members, are of record saying that they actually heard from staff people, we're sorry, we just don't have enough people to do this stuff.
That's correct, Your Honor.
I mean, I was focusing to some extent on Dr. Steyer's opinion that there were many inconsistent and inaccurate entries in the numerous fall risk screenings, so that even though she continued to fall, her requirements for assistance seemed to go up and down and more or less, which did not seem consistent to him. So at least there's an issue of fact, which is what very often happens when both sides have experts and they say different things. Maybe one's right, maybe one's wrong, but I didn't understand the vague and conclusory. So I mean, I was focusing on some of those things. I mean, didn't he indicate that somewhere in his opinion?
Yes, that's the second part and majority of Dr. Steyer's opinion. The fall assessments here, for the large majority, I believe 9 out of 20 total assessments were completely inaccurate. And if you look at the assessments themselves, and plaintiff's expert points these out specifically, there were blocks of missing information. She was being inaccurately scored time and again, resulting in her receiving low to moderate fall risk scores instead of a high risk fall score, which is what she should have maintained throughout the entire duration of her residency here. And these fall risk assessments that were inaccurate played a role in the proper interventions not being implemented, because plaintiff's expert testified that is what guides the type of interventions assessed to any particular patient. And here, if you look at the last 5 assessments prior to the date of accident in October of 2019, each and every one of those 5 assessments was wrong. she was labeled as low or moderate fall risk. And during that time period, the intervention of allowing her to walk with a rolling walker remained in place and was not changed, in part due to these low fall risk scores that were inaccurate that she kept receiving. So plaintiff's expert opinion in that regard was far from conclusory, contrary to what the motion court found, and we submit was more than sufficient to raise triable issues of fact.
Thank you.
Thank you.
You may proceed.
Thank you, Your Honors. May it please the court, my name is Mark Rechny, I represent the respondent, Shavir Rehabilitation and Nursing Center. I'd like to just first address 2 points made by the appellant's counsel. First, the issue of the ambulation with the rolling walker with extensive CIS+1. It's true that the resident was getting this intervention. In fact, what's relevant—
Was getting what?
The intervention of ambulation with the rolling walker with extensive CIS+1. But what counsel does not address is the fact that she was getting this assistance almost from the beginning of her admission there. So that means that in 2017, she was admitted, she was getting that assistance, and that assistance was specifically from the TV room to the dining room. So at a conservative estimate, twice a day, if she would be going to eat, that would mean that at least that occurred 1,000 times without any fall.
She fell twice in 2017. She fell 7 times in 2018.
What I'm saying is that no falls occurred with that specific intervention. So the mechanism that plaintiff is saying that occurred, that she fell with this going on, that is not the case.
Well,
in her reply brief,
I think I understand what your argument is, but we have a couple of different things working here. This is a summary judgment motion. We have these conflicting experts and the plaintiff's expert being very detailed in the level of intervention that would be necessary. And to address your point, just because that fall hasn't happened with that intervention doesn't necessarily mean that that was the appropriate intervention to have at that time based upon the history of this resident. So all of those things leads to denial of summary judgment, take it to trial, and then put forth whatever it is that you're saying right now.
well, respectfully, I don't think that the counsel doesn't address in either the appellant's brief the fact that there are brand new theories of liability that were brought about.
There are what?
There are brand new theories of liability that were only brought about in opposition to summary judgment. Specifically, the theory that the specific interventions of 2-person extensive assist, wheelchair use, hip pads.
Yeah, but
I'm sorry.
the Bill of Particulars allude to these in a general way, so you can't say you're surprised by this. You can't stand before us and say, oh, we were just shocked by this type of intervention that Dr. Steyer was trying to suggest in opposition to Dr. Diamond's report. You can't really say that.
Well, I mean,
This is a patient who fell 12 times. 12 times in your facility before this fall fracturing her hip. 12 times.
Respectfully, Your Honors, the counsel does appreciate the fact that there are 2 ways that her fall risks were assessed. There's the actual fall risk screenings, which occurred after a fall, and then there's the care plan that was put in place at the beginning.
And isn't it true that at a nursing facility such as this, assessments of patients for fall hazards is an ongoing thing?
Of course.
Right.
Correct.
So the fact, whatever the assessment was on 2017, when she entered the facility after falling in her house and having a fracture that brought her to your facility, right? So clearly she comes to the facility with a history of falls.
And that's exactly my point that I'm coming to now.
Okay.
Is that plaintiff's expert completely fails, and I'll point to the specific page in the record, completely fails to allege that there is anything improper, any error or omission with respect to the October 6, 2019 fall risk screening, which is the last fall risk screening prior to plaintiff's fall.
What was the patient's risk level prior to that fall? Just prior to that fall, what was her risk level?
I'm sorry, prior to the October 14th?
The October 19th fall.
October 14th?
Yeah.
It was on the October 6th screening,
Mm-hmm.
which plaintiff expert does not allege has any error or omission. She was assessed as a moderate risk.
Okay.
Now, it is
Why
plaintiff.
does just the last one matter? Why doesn't the history play a role in this analysis?
And I have to quibble with you on your statement that that plaintiff's expert doesn't quibble with that assessment when the expert opinion report says she should have been assessed a high risk for the entire time. So you're incorrect when you say what you just said.
But respectfully, how could she? You have to say each time there's a fall, there could be different issues that come up. As we all know, there are medications, there are different abilities.
He said she should have remained as a high fall risk throughout her entire stay, based on his review of the records. And I realize that you and your client disagree with that. I respect that. But that equals an issue of fact.
But respectfully, Your Honor, it's the plaintiff's expert's responsibility to address specifically, as he admitted, that there are screenings that changes occur in the patient's situation.
I mean, honestly, counsel, we've all read the plaintiff's expert's report, and it's quite detailed by date, by incident, by all the interventions that took place. It's quite detailed, which would be enough to raise an issue of fact. All of what you're saying, great. Talk about it at trial. This is a summary. That doesn't mean you're entitled to summary judgment.
This is one point that really troubled me. I'm trying to understand Dr. Diamond's report. Dr. Diamond initially notes that she has a boatload of health issues. I'm not going there. But he also notes that she has dementia, 97 years old. And then he later on goes on to say that, and this is where I can't wrap my head around this on the record. He says, Dr. Diamond opined that all of the plaintiff's falls were, quote, unavoidable and resulted from plaintiff's own noncompliance with comprehensive care plans and instructions in place for fall prevention. I can't reconcile that with this kind of record, that he's trying to say it's all her fault when she has dementia. She's 97 years old. She has all the, I just can't. Can you just clear that up for me? I mean, at the very least, it needs a full airing.
Well, there is a clarification by Dr. Diamond in the record that in spite of the prior falls having occurred in light of plaintiff's noncompliance, this fall did not occur in that way. So there was no way for that. This fall was unavoidable because it didn't occur in that manner. And that is in the record, and we cite that in our brief. But second, the issue of the history of falls, that was directly addressed in each fall risk screening. Each fall risk screening has a number of factors that you assess.
Yes, but as your adversary noted, there were multiple errors in those assessments. There were incomplete records in some of the assessments of the facility. In rendering her a moderate risk level, whenever they did that, there was missing information in the history.
But there's none in the risk screening directly prior to the fall, which also acknowledges.
Counsel, I mean, we can go around and around on this because I don't think that you are appreciating what summary judgment in this instance would mean, because there is conflict, and I think we're reading the expert's affirmation differently. Maybe we're interpreting saying that the expert does go through every single instance. I mean, it was very detailed, and very rarely do you see such a detailed expert's affirmation. It was very detailed as to what the intervention should have been. And so you're harping on this last incident with this particular intervention when maybe that wasn't the right intervention to have, and that's what the plaintiff's expert is. That is what denial of summary judgment means. Go to trial and deal with it then.
I understand, but there's also no actual claim in plaintiff's expert. There's no specific assertion that the care plan was incorrect from the start with the specific.
I think it does say that. So I don't know what you're reading. It does say that. Thank you.
Thank you.
Rebuttal.
Thank you, Your Honors. I'll be very brief. Even if we were to, consider this claim that the last fall assessment is, the key thing we have to look at here, I don't really understand the argument, because the expert does specifically point out how there was an error in that last final fall assessment. She was listed as a moderate fall risk, and they specifically failed to fill out the medication and disease factors section in that report. He specifically points that out. So I will yield the rest of my time. I just wanted to point that out. Thank you, Your Honors.
Murray versus Stone. You may proceed whenever you're ready. And good afternoon to you.
May it please the court, Frank Welser from Zuckerman, Gore, Brandeis, and Crossman on behalf of the appellants. This appeal concerns a very narrow issue within the New York long-arm jurisdiction statute relating to CPLR 302A3 subsection 2. That section pertains to jurisdiction over a defendant who commits a tort outside of the state, causing injury within the state of New York.
Yeah, but isn't the case law clear, and correct me if I'm wrong, that if you're dealing with an economic loss, which is the millions of dollars that your client had to spend to get these animals measured, well, I meant the safari and all that stuff, that the injury is where it takes place, which it all took place in Africa. Yes. Is that correct?
I understand your question,
Even if
Your Honor.
he's injured to the extent that he cut a check either in New Jersey or New York, depending on whether his company cut the check or not, and I'm being overly
I understand
broad.
your question perfectly, Your
So
Honor.
it's based on that, and since it's pretty clear that the defendant has no nexus to New York.
And your question stems directly from language within the court's order below. The court below cited to authority, which says that where damage is solely economic, the situs of injury is the location of original critical events which cause the injury, not the location where the resultant damages are felt. And the order on that basis considered that the measurements, the false measurements, were taken outside of New York and they were recorded outside of New York, and ended the inquiry at that point. It was a tight interpretation of what I label the OCE, original critical events, part of that analysis. The case law is not clear that is the end all. And 7 months ago, in a decision by
But
this
tell me
court,
how New York has sufficient contact, has an interest in this entire transaction. How is New York impacted by this transaction?
New York is impacted because the plaintiffs are New Yorkers.
No,
There's no.
that's not enough. The case law says that's not enough.
Understood. I
So
perfectly,
what else?
perfectly understand, Your Honor. Next, the defendant addressed invoices at the plaintiff's request to them in New York.
Not enough.
Not
enough.
One of these factors might be enough, but
That's not enough. That ain't it. Go ahead.
yeah, then there's more. Then the measurements were sent to the plaintiffs in New York.
But they weren't taken in New York. Not enough.
The measurements were paid.
The check was cut here. That's not enough either.
$2.1 million.
That's not enough. It could be $200 million. That would not be enough.
Next, the plaintiffs, in reliance on the fraudulent measurements that they received in New York, booked additional hunts with the plaintiffs, with the defendants.
Isn't it the important thing, defendants' connections to New York? I mean, for a long-arm jurisdiction, what are the defendants' connections to New York?
Your Honor, that is a factor, an important factor.
And
However, as this court's decision 7 months ago in the Bangladesh bank court.
Oh, thank you for bringing that
up.
No, it's
the checks were transferred in New York, weren't they? The funds were transferred in New York.
There are two.
The account was at the Federal Reserve Bank in New York.
Well, there are, in our case, there are two affidavits laying forth how the payments were made from New York in great detail.
In the Bangladesh case, it was a totally different situation because there were defendants had accounts here. Even though the hacking took place separately, I don't think that case helps you at all.
Well, Your Honor, that case says personal.
I know what the case said. I wrote it.
Yes, Your Honor, and the language says if there is no other nexus to New York, and the other nexus to New York here, it's not merely the fact that it was a
The only nexus to New York is your client. That's it. Your client is the only one here.
Your Honor, this is a case of fraud, and the defendants used the plaintiffs to further his fraud. It's critical that the plaintiffs printed up the false measurements that he either received by fax, this was a while ago, fax or email, and sent them to the SCI. And that's where
that's not enough, counsel. I mean, I understand how you're trying to make the stretch, but as everyone here has pointed out, this is an economic loss. You're pointing to all of the connection that your client might have to New York, not the defendants, and there was nothing particularly done here. Everything was done just because it was sent to. That's not enough.
Your Honor, the defendant, as he intended, orchestrated the plaintiff submitting the measurements, the false measurements, to the SCI from New York, and then the defendant got what he wanted. He was attributed as the hunter with these record hunts, and he got more.
Not anymore. He's not. Not anymore. He's not. Right? Because those records have been.
Oh, yes, and that's an element of damage. Our client was damaged because he took steps to.
You'll have time on rebuttal.
Thank you, Your Honor.
May it please the court, David Jacobson for defendants, respondents. As I think the court was observing, this case presents no meaningful contacts between defendants in New York, and there's no personal jurisdiction, and the dismissal should be affirmed. Defendants are South African. They've never been to New York. They've never had operations in New York or targeted customers in New York. Murray is an Australian who lives in and initiated the suit from London. Murray met Stone on a hunt in Africa and signed up for more. He told Stone he lived in London and provided paperwork confirming that. He flew from his home in London to the hunts and provided those itineraries to Stone. The hunts took place in Africa, as the court noted. The measurements were done in Africa, and Stone sent those measurements to Murray by email without knowing Murray's location. Murray doesn't contend that Stone knew where he was when they were emailed, and he actually admitted in briefing below that Stone didn't know where he was when they emailed.
What about some of those invoices that had a New York address on them?
Yeah, some of the invoices did. Some of the invoices had London addresses, and some of them had, one of them at least had a BVI address as well, and that was all just at Murray's request about how to address the invoices. But they weren't sent to those locations, they were just given those addresses.
Weren't they mostly emailed? I mean, who knows where you are when you email things?
Yeah, exactly. That's correct, Your Honor. Yeah, there's no the prerequisites for 302A3 jurisdiction don't apply here, and also constitutional due process is not satisfied here as it requires purposeful availment and expressly aiming conduct at New York, and there's no such showing here, Your Honors.
Okay.
Thank you.
Thank you.
Your Honors, the impact of a decision, of an affirmance of this decision would be that if a fraudster commits a fraud outside of the state of New York, that is, the fraudster records the fraudulent misrepresentation outside the state of New York, that fraudster could never be made to answer before the New York courts because of the mere fact that he wrote down the false statement outside of the state of New York. There's already a provision of the CPLR, 302A1, which deals with torts within the state of New York. This subsection, 302A3, deals with torts outside of the state of New York, which cause injury within New York. And Your Honor, I understand that one fact alone may not make this
Facts
such
in this
that.
case, it's a heavy lift.
Well, Your Honor, I tried my darndest in the reply to lay out every fact with record sites showing, and I believe that on
Look,
the
we
situations
appreciate
here-
that your client was wronged, but that is not the issue before this court. The issue before this court is whether there is sufficient contacts with New York in order to avail himself of personal jurisdiction. That's the only issue. So we are not opining on whether what was done to him and the lies perpetrated against him in this attempt at, this sport that people engage in is not the issue for us. You understand? We are stuck with the confines of the law as they are. That doesn't mean that we think what Mr. Stone did here was proper.
I mean, you made a valiant effort, but I said you made a valiant effort, but the facts of the case are what they are.
Okay, well, also under 302, I'll stop talking, but under 302A, provides for jurisdiction where a defendant outside the state does something either himself or through an agent. And here, for all intents and purposes, in terms of perpetrating a fraud, this defendant used the plaintiff as an agent to further the fraud.
He should have sued him in South Africa.
Thank you, Your Honor.
Thank you. Rabinowitz versus Clark. Last but not least.
Good afternoon. My name is Joseph Altman, represent the respondent plaintiff in this lawsuit. We believe that the decision of Judge Taylor of 9/15/23 has to be affirmed. There's no basis to even bring this appeal there. There's two causes of action, breach of contract, fraud. Both were timely. I don't even understand why the motion was made, and honestly less of a reason why they would proceed on the appeal. So we would ask that the decision be affirmed for the reasons set forth in our briefs and for the accurate decision of Judge Elizabeth Taylor.
Okay, any questions? Thank you so much.
Good to see
Have
you.
a good day.
Thank you.